Good morning, everybody. It's Monday. Heaven help us all. Welcome to the Courtroom Files Live. We're going to start with Mindy Glazer in Miami. She has a screen full of orange people. Let's see what that's all about.
His immigration hold would follow him to Georgia, and when he's ready to be released from Georgia, then they can decide then if they want to pick him up.
Entonces, esto significa que la retención de inmigración lo seguirá hasta Georgia y si en Georgia lo sueltan, entonces usted lidiará con el asunto de inmigración allá.
Okay, so I just need to hear you say, are you okay waiving extradition and agreeing to return to Georgia? They'll have up to 30 days to pick you up.
Entonces, lo que quiero escuchar es si usted renuncia a la extradición y ellos tienen 30 días para venir a recogerlo. Señor Miranda?
Sí, de acuerdo.
Yes, I agree.
That's a smart choice.
One last question. I don't know if anybody knows. What is the underlying charge in Georgia? Does anybody know?
He was on probation for a theft charge for stolen property in violation of a motor vehicle law.
Okay, perfect.
I'm sorry, Your Honor, you were cutting out and I couldn't hear the charges.
The underlying probation, he's on probation for a charge for theft by receiving stolen property in violation of a motor vehicle law. So Mr. Martinez is hopeful he may be able to help you in your case on that probation violation.
Señor Miranda, entonces su abogado quería cerciorarse de los cargos en sí que tiene en Georgia. Es por lidiar por unos objetos robados y también quebrantamiento de vehículo motorizado.
Okay, so hopefully he'll be picked up by July 8th and you can deal with whatever you have to in Georgia. Thank you.
Entonces, para julio 8 ya lo deben haber recogido, ojalá, y entonces usted puede encargarse de su caso en Georgia.
Have a good day, Mr. Martinez. Take
Que
care.
tenga buen día. Hasta luego.
Next is Alden Backus. He refused, Mr. Backus refused. He has locals pending. The next court date is June 27th, so we will reset his case June 30th. Then we have Jervis Mays. Where's Mr. Mays on Zoom? Here he is, Metro West 6. Good morning, sir. You have locals pending. Your next court date is June 30th, which is next Monday. So we'll see you on June 1st to see if you've closed out your Miami case, sir. Have a nice day.
What's the set for report date, Judge?
Well, I'm sorry, July 1st. All right, we'll see you next Tuesday. Have a good day.
Well, good question. So, I contacted Tennessee, and they were supposed to contacted you guys today about my extradition.
Right now they want to pick you up, and you got a Miami case pending, so we haven't heard from them, sir. So keep working on it on your end. If you're able to get them to lift the warrant, then you can post the bond on the Miami case and get out. Okay.
Bond's been posted for the Miami case. Is what I'm saying. So, the only thing.
Getting out, you're being held with no bond on this warrant from Tennessee. You shouldn't.
Right.
All that means now is you're not getting credit for time served. If you take a plea or go to trial and you're found guilty, you're not going to get credit for time served.
Okay.
Where was I? That's just the, all right. I need Emmanuel Williams. Hi, Mr. Williams. Good morning. What? You have a Miami case. It's set for June 30th, so we'll see you on what, July 1st. See you next Tuesday. Have a good day.
Oh, Miss Mandy.
Sure.
That'd be the 30th day from my expedition, correct?
Remember, you got the Miami case pending. We can't start pickup for Georgia until your Miami case is closed. Once it's closed, they have 30 days to pick you up. So it's set Monday. We'll see if the state files charges. Let's hope they dismiss it and you can get out of here quicker. All right?
Okay.
Have a nice day, sir. All right, then we have Andres Villegas. Is he here?
Yeah.
Plus 5.
Yes, ma'am.
Good morning.
Judge, Mr. Venegas has a hold for immigration.
Thank you. He also needs a Spanish interpreter. So, sir, unfortunately, Missouri needs a little bit more time to pick you up. So instead of picking you up by July 3rd, they need a 7-day extension, and they're going to pick you up by July 10th.
Ma'am, in Spanish, please. Translate.
Where's the interpreter? Is she there? Espérese un momento.
Bueno, señora.
I see a Creole interpreter. Do you speak Creole by any chance? No.
Good morning, Your Honor. The interpreter is present.
Can you please interpret for him? So Mr.
Yes.
Vegas was supposed to be picked up by July 3rd, but Missouri needs a 7-day extension of time to pick him up due to manpower.
Okay. Bien, señor Villegas, lo tenía que recoger el estado de Missouri para julio 3, pero ellos necesitan una extensión de 7 días por falta de personal.
So instead of picking you up by July 3rd, they're going to pick you up by July 10th, a week later. I'm so sorry about the delay.
Entonces, en lugar de para julio 3 venir a recogerlo, se va a tardar hasta julio 10. Siento mucho la demora.
And also, they now added an immigration hold, so that will follow you to Missouri.
Y han agregado una retención de migración y eso lo va a seguir hasta Missouri.
So reset date is July 11th. Have a good day, sir.
Nuestra fecha de aplazamiento es julio 11. Que tengan buen día.
Next, we have Julio Mojica Roman, a new case. No locals. Is he there? A pretrial? Let me see.
He's Ward D, Judge.
Reset Ward D. Okay. Reset Ward D then. Let me just make a note of that. Reset tomorrow for Ward D. So reset 624. But then we have Brandon Sarter. Mr. Sarter here.
He refused.
Refused. Mr. Sarter has locals pending. The next court date is August 7th. We'll reset August 8th. That's it for the out-of-state warrants. Thank you, Ms. Romas.
Thank you, Your Honor.
See you tomorrow. I hope we'll be here.
Judge, we have a write-in.
You have a write-in. I didn't know about a write-in. Who?
Morris Kirk, he's on Metro West Zoom.
I'm sorry. What is the name?
Morris Kirk.
Kurt Morris. Do we know why he's a write-in? Did he close a local case? What's a case number, please? Do you have his?
Fulton County, is that the in-state?
Yeah, it's for Fulton County.
Oh, that's for in-state, not out-of-state.
Oh, it's in-state, not out-of-state. Let me see. He's on the in-state calendar, not the out-of-state? Fulton, Georgia is out-of-state. Where's his?
Yes, Judge.
I don't know, you just put Fulton County, let me see his phone.
Do you know where you have
Out of state, Judge.
an out-of-state warrant? So did he close his local? Did he have a local? Is that what's up?
Yes, Judge, case is closed.
What's the case number for his fugitive warrant, please?
F25006878.
So warrant from Fulton County, Georgia. So apparently your Miami case is closed. Was he sentenced or is he ready for pickup?
He was sentenced to 90 days.
When is it 90 days up?
Do it say?
You want me to set it tomorrow to sort it out? Mr. Morris, what happened? Do you know? Because you probably know what happened.
Yeah, the cases are closed and I got credit time served already.
How long have you been in jail for? The whole time?
Since April 4th, so probably 2 months and 23 days, 20 days.
Judge, the sentence expired on June 25th, June 17th, I'm sorry,
He's
25.
been in custody.
And he's been in custody since 4/4.
When they calculated the CTS, sentence expired, so he's ready for pickup by Fulton County, Georgia. The deputy will be on this. I'll set it in 15 days for pickup for July 8th. Is that what it is?
July.
I'm gonna reset your case July 8th to make sure you get picked up.
Yeah, correction about this jail number.
What is his jail number, please?
250-132-516.
250-132-516.
Correct.
July.
All right. We're gonna start the pickup, sir.
Okay, thank you.
Okay, so that's it for the out-of-state calendar. Thank you, Ms. Romas. Now you're free to go. All right, now the in-state calendar.
So good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Monday. Good to have you all here. I wanted to take a second and again thank everybody on Friday for all of their generosity and whatnot. If you have no idea what I'm talking about, when this show's done, go back and watch Friday's live stream. It was exceptional how this community showed their passion for what we do here and also the generosity that they have. And it was just amazing. So to all of you again, thank you. If you're new here this morning, hang around a little while. Trust me, you'll like this place. And it has nothing to do with me. It has everything to do with the people you'll encounter in the chat. This is a good community. Let's move away from Judge Glazer for a little bit because there's a whole bunch of courts that are really starting to ramp up now. Let's go to Texas. We'll say good morning to Judge West. It's a Monday. If I had to make a guess, she's starting by asking people if they have a lawyer. Let's see if I'm right.
You talked to all of those?
Yes, ma'am. And
Hang on a second.
two of them I didn't
Listen,
talk to.
who'd you not talk to?
It was B. Holmes. She was on vacation when I called her, and another one I was waiting. JD Ham didn't call me back.
Okay, because he's a DA now.
Okay.
That's why I was asking.
Yes, ma'am.
So you actually talked to the others?
Yes, ma'am. I did speak to the rest.
And so where are you on being able to get someone hired?
I'm not gonna be able to.
Are you working?
Yes, ma'am.
Where are you working?
At All Code.
And is that full-time?
Full-time, yes, ma'am.
Okay, and what's your hours?
Monday through Saturday from 7 to 5.
And what's your hourly wage?
$21.
I don't know that you're gonna qualify for a court-appointed lawyer. I'm gonna, I'll have you fill out some paperwork this morning. You need to fill it out accurately and completely. You're gonna swear under oath that it's all true and correct. So put any income, any bills, and then I'll take a look at it and see where you stand, okay? You'll step in front of the clerk, she'll give you that paperwork. Yes, ma'am. Thank you. Bart Thibodeau. Bart Thibodeau. Okay. You know why my camera keeps getting moved? I'm all crooked.
No response, Jody.
Bond will be forfeited for non-appearance and reset at 100,000. Daryl Albritton. Good morning.
Hey.
You're Daryl Albritton?
Yes, ma'am.
And Mr. Albritton, did you get someone hired?
I'm still working on it. They kind of expensive because I had to pay for my daughter's funeral, so.
You could, I'm sorry, I can't understand.
I said they kind of expensive, so I'm still working on it because I just paid my daughter's funeral.
Okay,
And passed my daughter,
right.
so,
And you're working still?
yeah, I work in the plant.
All right, who'd you talk to? Which
All
lawyers?
these people right here.
Just tell me which ones they are.
Walt Wonder, Corey Crenshaw, Buddy. Yeah, I talked to some more on the phone. Them the ones I met in person.
Okay. So what I'll do, and I know you went through that with your daughter, I'm gonna reset your case about 30 more days to give you some time to try to get someone.
Quick question. The attorney you gave me, he said you gotta redo all my paperwork so I could rehire him or something.
So you were appointed Mr. Lewis when you were in
Yeah.
custody, but once you bond out, I expect you to hire your own lawyer. You've got a job, and you're making, so you need to try to hire your own lawyer. You're welcome to talk to Mr. Lewis about hiring him. He's still technically your court-appointed lawyer, but I expect you to try to hire someone before that next court date. If it's not gonna work out with the ones that you've already talked to, talk to at least 3 others. You can tell they all charge, and it's all very different. Bring me those names. If for some reason you don't get someone hired, let me know who else you've talked to and we'll discuss your options, okay? Thank you. If you'll step in front of the clerk. Roderick Anders. Roderick Anders. Bond will be forfeited for non-appearance and reset at 100,000. Brianna Clannon. Good morning. Are you Brianna Clannon? Answer out loud so I can hear you. How old are you? You're 20. Next time wear something more appropriate to court. Okay? Do you agree that that's probably not something appropriate to wear to felony court?
Yeah.
I tested you this morning. You gonna have anything in your system?
No.
Have a seat in the jury box. We're gonna get you drug tested. Gerald Jackson. It's like I don't want to say anything. I'm scared. Good morning. Are you Gerald Jackson? Mr. Jackson, were you able to get someone hired?
I was hiring nobody else, but he told me that he's no longer gonna do Beaumont.
Oh, okay.
So he referred me to Dustin Galmore,
Uh-huh.
and I was trying to hire him.
Okay.
The process, but he charged me $8,500, so I gotta get $4,200 to be able to get it.
Right.
And I'm trying to get to
That point. Okay. All right. So your case is getting old and you've got 3 of them. So we've got to try to get something done. See if you can get him hired before the next court date. If you can, great. Bring him the reset notice. If not, talk to some others. See if there's someone else you can afford and hire. If you can't, then we'll discuss your options at the next court date. All right. Step in front of the clerk. Shay Morgan. Good morning, ma'am. You're Shay Morgan?
Yes, ma'am.
Did you get someone hired, Miss Morgan?
I actually had the funds to hire somebody this morning. I got a call from an investigator on Friday, and my car was taken. So the investigator told me that it was not a real Geico agent, and he's taking money from my account. So they
Miss Morgan, you've had the most.
a mess.
I'm sorry?
A mess.
Well, it's a mess, but there's just a lot of issues that you're blaming on other people, and you've been coming here now for a long time.
No, I mean, I'm coming to ask to get a court appointed. I mean, or I couldn't hire an attorney because I felt like my income wouldn't allow me to get an attorney.
Are you working now? So what makes you think that if you're working, you would get a court-appointed attorney?
I'm just gonna have to resave the money. The whole reason I denied a court-appointed attorney was because I knew that I didn't qualify. So, basically my attorney they told me it was $10,000, so I had the money. And, I mean, I can show where they took it out of my account.
Where are you working?
Lake Pool and Water,
I'm sorry?
Lake Pool and Water.
And what?
Eastland, Texas.
Okay. And what are your hours?
I'm a finance manager, so it's just one of the places I work on.
I can't understand you.
9 to 7 usually. The dealership closes at 7.
Okay. And what, do you make an hourly rate or a salary?
No, my income, I started on the 8th and it was 8,300 a month.
Okay. You need to get a lawyer hired, and you need to try to get one hired before the next court date. If you're making $8,300 a month, you are not going to qualify. You've been coming for some time. This is your last reset. You need to find a way to get someone hired. No more excuses. Step in front of the clerk. She'll give you a reset notice. Lance Charbino. Good morning, sir. You're Lance Charbino?
Yes, ma'am.
And did you, were you able to get someone hired, Mr. Charbino?
No, I was not. I had called to 10 or 11 different ones, but I got the law office at James R. Nathan, DC, and then Roebuck, Thomas, and Adams, DLC, William Marcus Wilkerson's attorney at law. I just started working last week.
Okay.
And I am going to make a couple more calls to them if I'm able to.
Okay.
To be able to get me one hired.
Okay, sounds good. So thank you for doing what I asked you to do. I'll give you another 30-day reset. If you can try to get one of them or someone else hired, great, bring the reset notice to them. If not, just call some others, like you said, bring me those names so I know you're still trying, and then we'll discuss your options.
Yes, ma'am.
All right, step
Thank
in
you.
front of the clerk. Yes, sir. Ciandre Stevens. Good morning, ma'am. Did I say your first name?
No, ma'am, it's Andrea.
C. Andrea, sorry about that.
It's okay.
And Ms. Stevens, were you able to get someone hired?
I actually talked to Mr. Ryan Gertz, and he gave me his pay rate, and I'm about 2 checks away from giving him his down payment.
Okay.
But I have a question for you.
Mm-hmm.
Instead of paying a down payment for what he wants to start with, I have a lawyer who's trying to do the case for me for the whole amount that I can start off with Mr. Gertz. And I was wondering, just can I go ahead and use the lawyer I told you about the first time I used?
You can use whoever you want to.
You told me I had to get some more money.
No, I never said that. I never would have said that. So what I might have said was that and I don't remember our conversation because I see a bunch of people every week, but I can assure you I've never told one, because it would be illegal for me to tell someone they have to hire someone from a certain place. Now, hiring someone locally may be less expensive than someone coming in from Houston. Sometimes the people from Houston have issues getting here on time and things like that. I don't care who you hire. So absolutely, if there's someone that you want to hire that's more reasonably priced, as long as they're willing to come here for your court dates, that's fine with me, okay? So I'm sorry for the misunderstanding. I'll give you about 30 days to get whoever you want hired, and then bring the reset notice to whoever you hire, and they'll tell you what to do, okay? All right, step in front of the clerk. Luis Contreras. Wrong one? Okay. Good morning, you're Luis Contreras?
Yes, ma'am.
And Mr. Contreras, did you get someone hired?
Right now, at the moment, man, I'm struggling. My truck was missing for 2 months. It got stolen right here in Beaumont. Then we found the truck last week on Thursday, right here in City Spring.
Mm-hmm.
And they took everything out from the truck, my radio.
Are you working?
Yes, I'm working right now, but I'm struggling with the car right now. And I got 3 kids, and it's hard for me right now.
Did you talk to some lawyers?
Yes, I talked to Rojas, but Rojas said that, oh man, I'm gonna try to see if I can work it out with you. And so I'm trying to see if I can get somebody else, and it's hard.
Yeah, I understand.
I know my wife she's facing charges to this guy. My truck was stolen so for 2 months, so I was no ride for 2 months.
Okay. I'm gonna have you fill out some paperwork this morning, Mr. Contreras, to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely, because you're gonna swear under oath that it's all true and correct. So put whatever your income is, whatever your bills are, and then I'll take a look at it. Step in front of the clerk, she'll give you that paperwork.
The next one hired right then, McNally.
And wait,
I thought she could go.
she already did? Okay, thank you. Kashma Thomas.
Smith for state information.
Oh, don't worry about calling that name. Okay, I'll sign that. Thanks. Christian Ainsworth. Good morning. You're Christian Ainsworth? And Mr. Ainsworth, did you get someone hired? Did you talk to some lawyers?
This past month, very stressful. Like, next week, my mom just passed away yesterday.
I'm very sorry. And I appreciate you being here, even though that happened yesterday. So I will reset your case about 30 days. You can get past that. Call some lawyers in the meantime, okay? Once you get past the funeral and whatever you're going through, talk to them, see if you can afford someone, bring me those names, and we'll discuss your options when you come back. Step in front of the clerk. Deshandra Joseph. Good morning, ma'am. You're Deshandra Joseph. Did you get someone hired?
The last time I was here, I spoke to Verde, and we were having some kind of release from the IRS for releasing my taxes. So you gave me a couple more days. They still haven't released him. I reached back out to him to see if I could get him some kind of payment plan. He said that he doesn't do that. He needed $5,000 upfront, and I told him, because I'm a single parent, that I didn't have that. So I was trying to find people that could do down, like, payment schedules, and I just couldn't find anyone.
Who else did you talk to?
I talked to Brittany Holmes, and I talked to Prince.
Okay. And are you working?
Yes, ma'am. I work at a daycare.
Okay. Full-time?
Yes, ma'am.
What's your hourly rate?
$10 an hour.
Okay, I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely, because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. If you'll step over here in front of the clerk, she'll give you that paperwork. And then don't forget to grab your stuff when you walk back. Ronald Souls. Good, sir. You Ronald Souls?
Yes, ma'am.
And Mr. Souls, did you get someone hired?
I was told that I had my lawyer was supposed to be up here, but I'm going through like so much right now. My auntie passed, and right after she passed, my father passed. I had called the courthouse.
When did that happen?
My auntie passed in May. My dad passed like at the end of May.
Okay.
I was trying to get his obituary to bring it up here.
Okay. Are you working?
I got laid off due to definitely, well, my auntie, she lived in Atlanta, so I had to drive my mom to Atlanta. Once I came back from Atlanta, and my father passed, then I had to tend to his funeral, and I was laid off my job. I was working at the Verge.
Okay. Have you tried since then, now that all that's passed, have you tried getting another job?
In the process of it, but I'm trying to get a lawyer on this case right here, and I was told that I had a lawyer.
So when you're in custody, you're appointed a lawyer automatically, and that was Mr. Rojas.
Yes, ma'am.
But hold on, so now that you've bonded out, though, I expect you to hire your own attorney. We talked about that when you were here last time.
Yes, ma'am.
And so understand you've gone through some stuff. I'm going to reset your case for 30 days for you to try to get a job first. And I want you to talk to at least 3 lawyers to find out how much they charge, what their payment plans are, see if you can afford someone once you start working. You need to bring me proof of if you've gotten a job. I want you to bring me some kind of proof that you've gotten a job, a pay stub or something from an employer. If not, I want you to bring me proof that you're applying to jobs every single week. Okay? And then we'll discuss what your options are. All right, step in front of the clerk. Brandon Broussard. Did you hear from Mr. Kelly? Okay.
Let's switch back to Miami-Dade, and we'll visit with her again for a few minutes. Again, there's a lot going on this morning. There's a lot of courts in action. So I'm trying to scan through and see the best places to be this morning. There's some tough choices to be made. But let's go with Judge Glazer for a little bit.
Assault with a deadly weapon.
Bonjour, Monsieur Juni. Yo te arrêté donc cas qui t'est passé le 22 juin. Yo te accusé au côté c'est battre tout monde avec un zam.
So I will appoint the public defender's office for you.
Donc, ma bon avocat dans le bureau avocat défenseur public là pour représenter.
Is the victim in court? If so, can she raise her hand on Zoom to know?
Est-ce que victime dans notre tribunal, sous notre tribunal là, levé mais on sous Zoom?
So there is probable cause for aggravated assault with a firearm.
Moi, ouais, que gen assez raison côté c'est attaquer avec un zam?
No, ça va dire.
No, that never happened.
Your Honor, he has no priors. I'd be requesting house arrest level 2 plus bond. With a stay away order in place, there's no risk to the alleged victim.
Votre honneur, li pa gen antécédent, t'a mandé que yo bal résidence surveillée niveau 2 avec un lot campé loin.
Are you working for the state? Do you know what you just said to me?
I'm asking for house arrest. I'm
Yeah.
not sure what you're inclined
Said
to.
house arrest plus bond.
Alternate bond, Your Honor.
That's not what you said. You said house
Well, I
arrest.
would revise my request then to alternate bond.
Okay. Plus, that's what I heard.
Juge la mandé avocat ou travail pour l'État ou kon qui sa mandé moi, l'avocat a dit qu'on ça excusez-li, li corriger demande.
Ms. Laff, do you have an objection to that?
That's fine.
Sir,
Juge la mandé avocat l'État s'il y a objection, il dit non, pas un problème. I'm sorry, Judge. Go ahead.
sir, how long have you lived in Miami for?
Monsieur, depuis combien de temps habite Miami? 31 years.
Sir, I'm entering a stay away order from the alleged victim, your wife, whose initials are LE.
Monsieur, ma bon, l'autre campé loin de supposé victime nan initial li c'est LE.
No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties.
Ou pa gen doit gen contact avec victime nan directement, indirectement, ni dans téléphone, ni écrit, ni en personne, ni voyer commission pour lui.
No contact with the victim through social media or other electronic means.
Ou pa ka gen contact avec victime à travers médias sociaux ou bien aucun autre moyen électronique.
And he must stay at least 500 feet away from the victim, her home and school and place of employment at all times.
Et faut arrêter à moins à 500 pieds de victime, de côté le traité, côté le travail, côté l'école, tout.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
Ou pas cap gen aucune autre activité criminelle, ou pas qu'à utiliser ni posséder aucun drogue illégale.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Ou pas capable posséder, utiliser, acheter aucun arme, aucun balle, aucune ammunition.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Si vous avez balle, armes, ammunition avec un permis de port d'armes, il faut porter tout bail ça dans le commissariat à la police qui pipe la caille, il y a bon reçu ou porter reçu à notre tribunal là.
You may to the victim's residence one time only within 48 hours of your release from jail.
Pour qu'à retourner qu'à victime nan, dans 48 heures après au largué accompagné de pour capable retourner là 48 heures après au largué.
You must be accompanied by a police officer
Faut que gon policier qui accompagne
so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork, and work tools.
pour qu'on capable prendre effet personnel ou pour capable prendre médicaments, tout papier qu'on besoin yo, outils pour travail ou tout ça besoin dans cas.
Go to the victim's home without the police, or if you stay there, you will be arrested.
Sous retourner qu'à victime nan sans la police là ou bien sous rete dans cas là apparaît encore.
Do you understand?
Vous comprenez l'autre campé loin monsieur?
Oui, je comprends. Il y a des questions que m'a posées.
Yes, I understand, but I have questions. I don't know when I will be able to ask them.
What's your question?
Qui question gen?
Question bien, la police a été point depuis hier.
The police took the weapon yesterday.
Et police, ça ne va pas dire moi-même, c'est peut-être suspendre le téléphone madame. Moi, c'est ça fait les servir avec ça pour
And I did not touch the weapon. It's because I cut off my wife's phone line. That's why she's using.
Interpreter, can you also advise him not to speak about the facts of the case?
Monsieur avocat, on l'a dit pas parler rien, pas raconter rien de ça qui est passé. Tandis pas l'avant.
Oui.
Yes.
L'autre question que j'ai pour me travailler de monsieur, comme si les 48 heures d'abord qui est venu, est-ce que je peux avoir un matériel de travail moins pour me reporter dans le travail, ou bien avoir mon chercher pour moi?
I have to work tomorrow. Can I go and pick up my work tools, or can I send somebody to pick them up for me?
Your lawyer can answer that for you.
Avocat on l'a ka dit ça. Monsieur, c'est pas pour 48 heures, non, ou bien 48 heures pour aller chercher ba yo.
Oh my God. Okay.
I clarified, Judge. He thought he had to wait 48 hours, so I explained to him that he's
48 hours.
Yes.
So does he have any other questions for her or
Ou
no?
gen l'autre question pour juge là, monsieur?
Oui, me demander après combien de temps je suis capable de retourner à la caille moi?
I want to know after how long can I go back home?
Well, while this case is open, you're not going home. You have to stay away from the victim.
Pendant que cas ça l'ouvre ou pas ka la caille, ou faut arrêter loin victime nan.
Sorry, Your Honor.
Go ahead, you go ahead.
Tell him if he can call, speak to the lawyers, we can give him all of his options and talk to him about those things.
Avocat on l'a dit la bon numéro téléphone bureau pour relé la pral do ki choix ko gen puis il pral parler sur tout bail ça.
Okay, next, it's house arrest, GPS monitor, level 3 house arrest.
Résident
Go ahead.
Résident surveilleur niveau 3 bagay nan pied, moniteur nan pied.
Alternate bond, $5,000.
Ou bien payer caution $5,000.
Have a nice day, sir.
Passez bonne journée, monsieur.
Merci. Thank you.
Thank you.
Madam Interpreter, you're excused. Thank you so much. We'll call you.
Judge.
Do I need to contact you?
No, not now. It has to be another day.
Okie dokie, let's change it up again. Let's go to Wisconsin. We'll see Judge Mogan. Haven't seen her in a few days.
We have Christopher Gramstrup, defense appearing by video conferencing. We have Ms. Ekstrom in court. We're set for status conferences. Mr. Gramstrup, can you please update the court?
Yes, Your Honor, court will recall that we had this set for a plea and sentencing a while back, and Ms. Ekstrom failed to appear. It's my understanding, at least at that time, that we had the matter resolved. She was picked up on the warrant and posted, I think, $250 cash. Since she's been released, I've not been able to reach her. So I'm assuming that she still wants to proceed with the plea and sentencing, but I've not been able to confirm that with her.
Ms. Ekstrom, is the matter resolved? If it is, I can take care of it today and be done.
Well, so my concern is this. I'm not working right now. I am looking for work. Because the warrant's taken care of now, well, you know, I was in jail, and so since that's taken care of, I think I have a better chance of finding a job. I can't pay everything back like right now, but if I could set up a payment plan, I just.
Oh, that's right. It was a prepay restitution.
Yeah. I really literally just want everything taken care of. I'm trying to like get my life on track here. And if I have to keep coming to court for just the same stuff, I just want everything taken care of. So that's my main concern.
All right. So right now, it sounds like it's resolved.
Right.
It's just she needs some time to be able to come up with restitution.
Yes.
Or it needs to be a payment plan. So would we need one more status, or would we?
Yeah, actually, I think the offer was contingent upon prepayment of the restitution. That's accurate. If she prepaid, there is an alternative offer if she doesn't prepay the restitution. But I think what she's expressing is she still wants to take advantage of the offer that involves prepaying the restitution. So I don't know how much time she would need to do that.
And I think we only have the $250 from the bond, and so that can go towards restitution. So
yes.
And I'm not as worried about the court costs and fees. That can be a
Okay.
payment plan, whatever.
Right.
It's just making sure that restitution. is
Absolutely.
due. Are you looking at something, Mr. Schmidt?
I was just saying what the total amount was on the
I think it's
restitution.
$1,015.15.
$25.50.
Oh, $25? Okay. All right, so you're looking for a job and you should be able to get
Yeah.
a job. You just need some time.
Yes, ma'am.
Are we in victims' rights compliance?
Yes.
I could do August 12th. Would that be long enough?
Oh, I would hope so. Gosh, yeah.
We can do August 12th at 9:45 if that works, Mr. Gramstrup. And I'm okay if you appear by video, if it's okay with Ms. Ekstrom.
That's fine with me, yes.
That works just fine, Your Honor.
All right, August 12th at 9:45. We'll set it for a tentative plea and sentencing, okay?
Perfect.
All
Thank
right.
you. Do I have
Thank you.
to come up here
You
for
can come
anything?
get your notice and then you're free to go.
Jatisha,
yes.
I need you to figure out what's going on with your phone so we can communicate.
Oh, can I give you a accurate number right now?
Yes, we need.
We'll just go ahead and mute while she does that. So Judge Mogan is always a joy, but that wasn't the most engaging of hearings. Sometimes we run across those. Let's go back to Texas. Judge Stevens. Say good morning to him.
If convicted. There is a recent report prepared by Dr. Edgar Kahn upon examining the defendant, and this is dated May 30th, 2025. It's also one dated May 21st, 2025. And these are similar based upon an evaluation on May 13th. And the defendant is declared competent by Dr. Ed Wilcon. I am calling these course exhibit number 1 in this for today's date. Any objections? No. This would be a part of the record. Sealed and
It's been a while since I looked at it. Does it evaluate only competency?
take your names. And May 30th, Dr. Edgar Kahn not only reaffirmed his earlier analysis of competence, but went into the issue of sanity or insanity. It's all on you. What do you think that's gonna be? Very good questions. I think he thinks out there is gonna go top. Yeah. Fine. Right. But you got a copy of this May 30th report? You got this one. That's 21, yeah. And then Dr. Dupont went on to take up the issue of sanity or insanity on his 30th day report. Okay. None of that. How about this one?
What's the good doctor's opinion about that second issue?
It's we got this. Some competing issues is that the defendant is brought to the hospital with what is reported as a drug overdose in an attempted suicide. And he wakes from sedation in a disoriented state and attempted to remove the breathing tube, kick the nurse who was trying to assist him, which is, I think, where the assault occurred.
Yes, sir.
His version is the defendant states he doesn't remember. His diagnosis is deliriums, which is now long resolved. Now, delirium in psychoanalysis is a state of mental confusion and reduced awareness characterized by sudden onset of symptoms consistent with confusion, disorientation, and difficulty thinking clearly. It is a serious but treatable condition characterized by sudden change of mental state, including confusion, disorientation, and reduced awareness. Any delirium is a serious disturbance in mental ability that results in confused thinking and reduced awareness of one's surroundings. And it is obvious in this case, the man was suffering from an obvious delirium. He goes on to state that the determination of sanity or insanity is the province of the trier of fact. And the problem we have here is we got some competing interests. He's suffering under what Dr. Edward Pond calls confusion, delirium, but it's from overdose of drugs, which is not an excuse. You can't overdose on drugs and then start claiming defenses. So
But it sounds like he's
fact finder to make a decision on these competing interests. But it's, I think everybody would see, can see if somebody is is misusing drugs and then is being treated and starts beating up the medical personnel. We got problems. Medical personnel to be protected, and there is the issue of the patient, if they are in a reasonable state of mental awareness. But if they are not, because of their volitional misuse of drugs, that's not a defense. That's for, I guess, a fact finder to listen and weigh and make a decision over. But you can't say I'm going to misuse drugs and then later harm personnel who are trying to treat you.
So
if that were allowed, I think most people would say who show up to treat or to take care of someone, and then they find out that this is a misuse of drugs, then why would they want to put themselves in harm's way? Because they can be harmed, and then there's no accountability for it. That's not, well, that it does not seem to be a social standard that we want to go down. Yeah, people need to be treated when they're not well, but the treating authorities should not be left without any type of defense under law. And otherwise, people are going to, ambulance aren't going to start showing up at locations if they find out that it's drug overdose. It'll get out pretty quick. But they've got other things to do that are more important than self-harm. So that's what it states, and it's a fact is for the fact finder. You want to go to the judge or the jury, that's your call, but it's a possible defense that can be raised, but it's not for, it's for the fact finder to decide, and he's competent otherwise. So set it for trial.
But have you been able to talk to him about the offer, or?
I have.
Okay.
I've given him the offer. The last offer we got was a cap of 8 years. I did get that to him, and
all right, you told it to him. It's his decision. It's set for trial, and we'll let a jury roll it out. And
he has a lengthy criminal history and is not probation eligible.
All right, anything else? You understand where we are, sir?
yes, okay. The attorney said, yes.
Anything else you want to add, sir? No, just
my power of attorney was not notified that this was happening today, and I'm trying to get my attorney to call my power of attorney, my caretaker, to be here. I have traumatic brain injury and seizures. I've been in the hospital all day yesterday and tonight, and I was missing this court date last time because of having seizures in the hospital. But I need my caretaker here.
We'll subpoena those records.
okay. Anything else? This is set for trial. Thank you. Next is
Let's stay in Texas, but we'll head west of where he is, and we'll go to San Antonio. Say hi to Judge Boyd.
Is calling 2023 CR 9149 State versus Gabriel. Antonio Sosa. Could I have parties announced?
State Attorney Middleton for the Sense.
And are you Mr. Sosa?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
I did, yes, ma'am.
Are you the same Gabriel Antonio Sosa who was placed on deferred adjudication in 2023 CR 9149 for the offense of it should be possession with intent to deliver a controlled substance penalty group 1 gram to 4 grams?
Yes, ma'am.
They've listed as manufacturing and delivering in the motion. So state, do you wish to change it to possession with intent to deliver so that it can track the judgment?
Yes, Judge. No objection, Your Honor.
All right. So are you the same Gabriel Antonio Sosa who was placed on deferred adjudication in 2023 CR 9149 for the offense of possession with intent to deliver a controlled substance penalty group 1 to 4 grams on or about on the 9th day of November 2023 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state, you may proceed.
In Bexar County, Texas, the defendant Gabriel Antonio Sosa did then and there failed to report to the supervision officer as directed for the months of March and April of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True. State waives the remaining violation allegation. No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Judge. Denied the motion, alter and amend, required state ISF cognitive, followed by 6 months sober living post state ISF.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Gabriel Sosa,
All right, so why are you not reporting?
just overwhelmed.
All right, why were you overwhelmed?
Just a lot of things that going through my mind.
What are these things?
Parents, kids, everything. A lot of things just overwhelming.
All right, so what I'm reading in the violation report is that he was released from DDRF and then he didn't comply with his mental health officer.
I reported for like 4 times.
Mhm.
I reported for November, December, January, and February.
They're saying that you haven't been compliant with your mental health treatment either.
I was taking my pills and going to the psychiatrist. That was. Maybe they're saying that because I stopped reporting, but while I was reporting, I was complying.
Well, no, they're the same. It says Mr. Sosa has not been seen by probation since February 28, 2025. And per the Center for Healthcare Services, they have not been able to find him since around the same time.
Yes, ma'am.
And you've been drinking excessively. So you've been acting as though you're not on probation. And I don't know if ISF is appropriate for him because he has mental health issues.
Your Honor, if I may, in my consultations with Mr. Sosa, I think maybe unpacking the idea of being overwhelmed, and he was clearly admonished that the court would not be too open to that argument, but understanding he was in custody waiting on a bed for DDRF for 6 months. That's just how that works. There were some issues that developed around his family and those obligations at that time. Then when he got to DDRF, he was compliant for a time. Then they released him again. He was reporting. He did come off the wagon, but what I can tell the court is that one of the first things he mentioned to me when I mentioned these issues was that he understands that he messed up and that he recognizes that part and parcel to his mental health issues is an addiction issue as it relates to alcohol. He wants to get that fixed in terms of the recommendation from probation and that the state's in agreement with, and that I told him that that's what, and that he's in agreement with, is that he does need some of those cognitive tools to continue to recognize that the court is well within its bounds to sentence him to 20 years on this. But that's not why he wants to change. He wants to change for his family. His family is also referenced in the report. where they had mentioned that he was having some issues with drinking. A big part of that is his openness with them and his wanting help for that. We would also point the court in the direction that it wasn't, we understand that the safe, if he hadn't been reporting for multiple months or for years, that's the thing, but he was picked up. I mean, his last time that he had contact with them was February. He has been in custody for over a month now. So basically, again, with no excuses being given, he was basically in the wind for about, my calculations, of course, not a math major, about 6 weeks. He is here today, contrite, asking the court to give consideration to the recommendation from probation. He understands that while he may not be deserving of a second chance, a lot of us are not worthy of second chances, but he is asking the court for another chance. But with DDRF, all of those things that were given to him, his medications, that's kind of yielded to that overwhelming feeling. I think really the feeling that he was really describing was probably one of desperation, not knowing what to do with the things going through his mind. The court's also aware with DDRF and with medications prior to DDRF, you were prescribed some new medications. Is that correct?
All right, so here's my question. My question is whether or not ISF is appropriate for him. He has mental health issues and he is currently in the throes of his addiction.
Judge, I believe what probation's, the train of thought there was, if we can get the substance use under control first, and they do have a cognitive aspect to it. I think state ISF would be the best place right now.
All right, and that's state ISF for drug as well as
Yes,
cognitive?
cognitive and substance.
All right, thank you.
You're welcome, Judge.
All right, Mr. Sosa, I'm gonna give you a choice. And these are your only two choices. Don't ask for a third because there are only two choices. One, I can deny the motion, alter the main conditions. You'll be in custody until ISF comes and takes you and transfer you to their facility. Or I can revoke you and I'll sentence you to 3 years in the prison. And you'll receive credit for any time that you've been in custody. Which do you prefer?
Can I refer? Can I start something? And Your Honor, if he were to take option 2, given that he successfully completed DDRF, that would count towards his time.
Yes. And Bashan, any updates on BTC?
Judge, they were just parking, a minute ago.
Okay, awesome. Christina? Christine, hey, BTC should be down in a moment. They were just parking. All right, thanks. Yes.
Your Honor, given all the circumstances, he would give consideration to the court's offer of option B.
So you want to be revoked?
I can do that 3 years.
Mhm.
Yes, ma'am.
All right, the court is finding violation of condition number 2 true. The court will find you guilty. The court will revoke, sentence you to 3 years in the prison, give you credit for any time served. The court will request the therapeutic community. And the court will give you credit for any time served, and inpatient treatment, which legally I'm obligated to do. All right, are you waiving your right to appeal?
Yes, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
I did.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You sort of chose the easy way out, which I understand, because you know yourself better than your attorney knows you, better than I know you. But one or two things are going to end up happening to you if you stay on the track that you're on. You're either going to end up spending the rest of your life in somebody's prison, or either somebody's going to end up having to identify your body because you've obtained some bad drugs. There are plenty of free places where you can get help for your mental health issues and also for your drug issues. Once you're released from custody, if you can't find a place, let me know. If I'm here, I'll find a place for you. All right?
Yes, ma'am.
All right. Good luck to you.
Thank you.
You're welcome.
Maybe excuse me.
Yes.
So yeah, he chose prison. Jim, you raised a point. Depending on time served, it might be a better option. That is true. I don't think they made it clear exactly how much time served he has, so that's a possibility. I think you also have to consider that some people just get institutionalized, so to speak. I mean, it becomes a more comfortable place for them. I don't know exactly what this guy's background was, but I think that probably affects that decision for a lot of people as well. But, you know, people make their choices. He made his choice, and we'll see where it goes and hopefully it works out for him. Let's head back to Judge Stevens.
Versus Michael Ozzie Baltazar Aguiar, correct? Yes, ma'am. She's going to need you over here, right over there to get your fingerprint. Thank you, sir.
Right, Tom? Same time.
Yes. All right, the defendant is present with his attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Yes, you proceed in summary? Yes, sir. Is it just paragraph one? Yes, sir. It's all that's needed, Judge. Paragraph one states in this indictment, sir, that on or about July 23rd, 2024 in Jefferson County, Texas, you committed a third-degree felony of unlawful possession of a firearm by a previously convicted felon. Do you understand what you were charged with? Yes, sir. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement? If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to assert guilty or not guilty? Are you pleading guilty voluntarily or is on your own free will and because you are guilty? I show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? With the contents correct? State's Exhibit 1 tendered into evidence without objection admitted. Among other things, the state you are mentally competent to enter this guilty plea. It's freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You're guilty of the crime charged in any lesser included offenses. You are giving up your rights to the jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is here for state, so help you God. State's Exhibit 1 is part of the record. Without objection, pre-sentence report is way. Yes. If nothing further, sir, I'm going to follow this agreement and find you are pleading guilty voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of unlawful possession of a firearm by previously convicted felon. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years as the court finds you guilty beyond a reasonable doubt based upon the evidence here. You understand what has happened today, sir? Yes, I'm just TDC. You will be given credit for all time. Yeah, you've served in accordance with this case. as everybody does. But you know how much you've served. Okay, thank you. That is fine.
Let's go back to Miami. Judge Glazer still growing strong. She's a good couple hours in now. They have a lot of crime there. She never stops. I'm pretty. She must be a robot. I mean, every time I go to this court, she's still
Three
going.
will be $7,500. Count two, the domestic domestic battery by strangulation. I think the better charge is child abuse since it's a stepson. That's $5,000.
Your Honor, as to the count of criminal mischief, I see on the arrest form, it says that he damaged a door frame with a knife, and then it's approximate at 100, and then the cell phone is conveniently approximated to 900, making this just up to the felony threshold of criminal mischief. But I'm not sure unless this is a, brand new iPhone and he perfectly damaged the wood. It seems to me like the criminal mischief is a misdemeanor criminal mischief for over $1,000 or under $1,000. So it after reduce.
Right at the threshold, so there's probable cause for felony criminal mischief. I'll set count three at $1,000. That's so the house arrest, I'll do level 3 house arrest with a you want curfew state?
No, you just gotta stay away from them for the time being.
Victim, sir. Good day.
And was that plus or alternate house arrest, Your Honor?
Alternate house arrest, level 3, alternate bond, 7,500 count 1, 5,000 count 2, 1,000 count 3. Next case is Steve Genaton, page 5. Good morning, sir. You were arrested for driving with a suspended license, third or subsequent conviction.
Judge, Mr. Jennington has a writ of body attachment with a cash bond of $2,500.
Okay, he keeps driving. He has a history of driving.
So if he gets his child support straight, then maybe he can get his license straight.
Go pay your child support off or work out a plan. There's probable, let me see something. So you want it says 13 suspensions.
But then later it says 4 convictions.
There's probable cause. All right. You want to take more people? All right. Pretrial services, alternate bond, $2,500, no drive order, no driving unless you have a good license. So go pay off your child support or do what you got to do to get that D6 clearance and get your license reinstated, sir. Have a nice day. Next is Ramses Sue. Page 5. Good morning, sir. You were arrested for battery, 2 counts of battery on a law enforcement officer, 1 count of resisting with violence and disorderly conduct at an establishment. I will appoint the public defender's office for you. Although, can you afford a lawyer? I guess I should ask. Can you afford to hire a lawyer?
No, ma'am.
Public defender's office is appointed. Let me take a look. They pushed the officer. He was told to leave the premises. He refused. Then he also resisted. All right. He also spat in the officer's face. He was drunk. So you are ordered to stay away from the PBR Bar at Dolphin Mall at 11401 Northwest 12th Street in Sweetwater, Florida. You are not allowed to go to that location and you must stay away from there. Do you understand, sir? All
Yes,
right.
ma'am.
Are you okay if I split 1 and 2? He was drunk.
Okay.
$2,500 count 1, 2,500 count 2, count 3, the resisting an officer with violence. I'll set it at $1,000. Count 4, disorderly conduct is $150. I lowered your bond a little. Good luck to you, sir. Okay.
On in total, please.
$6,150. So I lowered it from it should have been 7650. So I set it at 6,000 total. Let's see if you went 3,500, something like that. 5, 6, something like that. Next we have is Martir Bustelos.
Judge, can we take two at a time for corrections? They have to go to DV court.
Who is this?
On page 9, Sharon Kane.
1 second. Okay, page 9, Kane Sharon. Good morning, sir. So you were arrested for criminal mischief over $1,000 in damage and burglary to an unoccupied structure. I will appoint the public defender's office for you. This is a case from May 31st of 2025. So we entered this Flowtech office and damaged 3 surveillance cameras, $1,000 value, hitting them with an unknown blunt object, and then damaged an air conditioning unit, $1,000 value, by hitting it with the same blunt objects. And he broke another lock. So I don't know, it just says what they're worth. Does it say the damage value? No. I say it doesn't list the amount of damage.
It says the same individual damaged a mini AC unit, $1,000, and I don't know, Judge. I mean, to find PC on the burglary and then a misdemeanor.
So you were ordered to stay away from the Flowtech business at 3800 Northwest 29th Avenue in Miami, Florida. You are not allowed to go to that location. You must stay away from there, sir. I'm setting a bond, count 1, criminal mischief. I'll set it at $1,000. And count 2, burglary to the unoccupied structure is $2,500. Have a good day, sir.
Judge, the next defendant is on page 11, Javier Exposito.
Okay, 1 second. Javier takes something.
Let's go back to Judge West and see how her parade of fashion is going.
I did, Your Honor, I saw some.
Cameron Gutierrez.
Safety.
Oh, I see that, yeah.
Yeah, and, let's see, I believe the court signed the order, but.
I did, yeah.
Yes. Oh, and Judge, I did get a response. I need to go back through my file. I don't want to misspeak, but I did get a response. I don't know that those records, after so long, were maintained. It's what my memory is.
Okay, so why don't I just do about 30 days, and then Mr. Coleman, you can check on that, let Mr. Franklin know any information that you, hey, y'all, any information that you've received, sorry, lost my train of thought. Get together, see if we can get an announcement the next court date. Thank you.
Thank you.
Mr. Price, let's see, is Chris still, Mr. Romano? Mr. Kelly, I understand you're.
Somehow.
Thank you.
Thank you.
All right, so this is the bond forfeiture docket, Nisi, case number 24 DCCV 1018. And I guess these are both kind of similar issues with regard to the same bonding company, correct?
I think they're identical.
And then 24 DCCV 1321. Mr. Kelly or Mr. Romano, what's?
On Mr. Celestine, and again, I think the issues are the same here, is that the defendants in each of these cases, in Mr. Celestine's case, he was ordered, I think, by the court to get a drug patch on one setting, given 24, 48 hours, go get a drug patch, come back, or give us notice that you've done so, and for whatever reason didn't. So my interpretation of that is a bond that should have been revoked by the court not forfeited or left Mr. Romano and his company responsible. That was an issue between Mr. Selstein and the court. I think the issue is the same.
Did I, well, I mean, if he,
You ordered it in court one day. He apparently showed up to court and we weren't notified at the jail that he had to have one. So his first day, you showed up and said you need to have a drug pack within 24 hours. It didn't get done. We didn't know it didn't get done. And so the next court date, we moved the hearing up and he didn't show up to court. So that's kind of the issues on both of these.
but if I had, did you not know about the court dates? I mean, regardless of, if there's a bond violation, a lot of times what I'll do is, if it comes to my attention through, Ms. Werner will get the emails from whoever it is that they're supposed to have a GPS or a drug patch. And then if I get some type of referral back from them that says either they're not wearing it or they didn't get it or they tested positive, sometimes if it's a positive, I'll at that point just raise the bond and do an at-large without proper bond. If sometimes though, I'll, instead of waiting till the next court date for these violations, I'll move it up a week or two. So I guess if I moved it up, which is what it sounds like for a bond hearing, just a review to see what's going on. Are you saying you didn't know about that date?
No, we knew about the court date. What I'm stating here is when we did the bond, the drug patch was not a part of the bond that we did with the client. That was a condition between the court and Mr. Celestine on this actual situation.
Right.
And basically, what I'm stating here is some of these bond conditions are setting us up for failure. I mean, like this guy, you gave him 24 hours to get the drug patch put on. Okay. But he knows he didn't get it put on 24 hours later like he was supposed to. So at that point, the bond should have been either at large without proper bond. I mean, even if we want to do judgment issues, they can be defendant onlys because we're the ones getting punished here for bond conditions that when we post these bonds at the jail, we don't have much to know about. I mean, the next guy violated 18 times bond conditions that we didn't know about until the day of the hearing that he forfeited on.
Yeah, may I respond?
Yeah.
There's a couple of things. Number one, if the bondsmen want to know what conditions, what changes are being made here in the courtroom, they should attend the hearings. It's not appropriate for the court to.
Well, let me stop you. I think the conversation that we need to have is probably something that we need to have maybe at a bail bond board meeting where we can address if and how those conditions can be relayed when we do them here in court to you guys. But the thing is that's every court does it differently.
Yes, ma'am.
But the court date and the bond forfeiture, it is what it is. I mean, they didn't show up. You're not saying you didn't know about the court date. And so I think regardless of why I set something, whether it was because of a bond issue, that to me, we're talking about two separate things. Somebody didn't show up for court because of a violation of a bond condition, but they didn't show up for court. So that's a forfeiture. If I know, it's just different on how, it depends on, for me, how I handle them. And we can talk about that later.
So on the next one, the state even filed a motion to increase or revoke. We set a hearing for that. He had violated 18 times. We didn't have any notification from the ankle monitor business. And we have no grounds to drop him when he is violating those conditions.
No, I understand that y'all might need some type of, I understand.
So I'm asking some kind of relief because this next, I mean.
Well, I don't know that I knew someone violated 18 times.
I didn't say you did.
No, I'm just saying, I don't know that either of us
Yeah.
knew that, because if someone's violating an ankle monitor 18 times, typically it's going to immediately be at large without proper bond, not just let's reset a hearing for a week out, because I would be concerned about that. So sometimes we may not get it from the company until they say, oh, look, there's been a whole lot of these. And so we don't know that either. So that's obviously something we need to take up. I guess,
Your Honor, if I might respond.
yeah.
Section 2213 does not list the court changing bond conditions as a grounds for exoneration on the bond. I mean, it's simply not there. I mean, it's the court has to address the defendants as the defendants appear in the court. The bond conditions for the jail. Right now, Mr. Romano has not told the court that they can't go over to the jail and pick up a copy of the conditions that are placed on them at that time. I don't know why they're not getting communication from the.
Well, no,
ankle
he's,
monitors.
he's getting them, they're getting them
It's fixed
when
now.
they're initially done.
Yeah, it's fixed now. That issue.
That's been,
Okay.
yeah, we've been working on that.
Otherwise, they
But
can
what
attend
he's
here.
not getting is their information here. And I understand that they can't also be in every court every morning. There's, I don't know how many people they have working for them, but we've got 4 or 5 courts going on. So I understand that there's an issue potentially with getting that information. I don't think it changes legally, though, the fact that there was a court date, knew about it, the defendant didn't show up for that court date. And so I don't think legally there's relief necessarily that I could give unless there's some agreement to that. I do understand where you're coming from, but I think the fact that y'all knew about the court date, there wasn't some communication issue with knowing that he had to be here, or both of them were guys, that they had to be here, and that it didn't show up. I understand what you're saying. If you knew that there were those violations ahead of time, maybe y'all would have filed an AFRS or whatever.
That's part of what my thing is, we can't. We do bail bond agreements with these people, and it spells out what grounds we have.
Right.
So these violations have to come from the court as far as the issuing of warrants, and I can't even go rearrest them. We have a investigations company, but I can only go pick up on our forfeitures. So even if we do it at large, my hands are tied on some of this. And Mr. Price just wants us to keep going after these people, and I understand that. But even on this kind of situations, I can't go after these people. I can't even issue a warrant for them. Legally, I cannot, because they could come back at us and go, well, here's what our contract says. Well, the bond conditions were not part of our bail bond agreement.
Well, what if, we need to talk about that later too. Make a note, because why can't y'all put in your bond agreement that it's any bond conditions that are there and any bond conditions that the court orders?
That would be something we have to do after the fact. So sometimes, like now, we're knowing bond conditions. This isn't an issue that's gonna keep coming up because they fixed it at the jail. But this is some of the old stuff that we didn't know until we get blindsided, like.
So were these my conditions on both of these, or were these conditions that were, because I think that is different. If these were conditions that were placed by the magistrate at the jail, or were these conditions that were placed on them here in court by me?
I'm sorry, Judge, on Mr. Celestine, I believe that was the courts.
Yeah, that was the courts.
On the drug patch.
Okay.
These were the court's standard conditions because they're general violations anyway.
Mr. Ortiz, I think, is gonna be yours also.
Okay, so these weren't the jail issue. Okay, all right, then I'm going to grant the forfeitures in each case, and then we can discuss somehow, if you gotta get with all the courts though, to figure out a way to get bond conditions that are placed on them after the fact by the court, which happens all the time. And so I don't know, really, other than y'all being here, but we can try to work something out. But I don't think that's necessarily the issue's going to be getting everybody to do with the same. But we can talk about it at bail bond board. All right.
Your Honor, just for clarification, I would ask that the court take judicial notice of the court's bond forfeiture docket for the cases thereon.
We'll do so.
And take judicial notice of the bond forfeiture case and the underlying criminal case in each of those.
We'll do that as well.
And enter judgment according to the court's docket.
I will do that as well.
We have final judgments prepared for that. Your Honor.
Okay, thank you.
Thank you, Your Honor.
All right, and hey, remind me, and we'll try to figure something out. All right.
Okie dokie, just an FYI for those of you who are with us now but were not here for the pre-show this morning. I did put people on notice that this week's going to be a little bit different. For those of you who are not in the know, my daughter came to visit me this week, so I'm spending more time with her, which means I'm going to be putting out a little less regular content this week. But what I can do is do a little bit more of a live show, so we're going to add a third hour all week long. So be sure, if you're watching at work, to put your boss on notice that you're going to need an extra hour for the courtroom files this week every day, and they'll just have to live with that. Let's Let's stay in the building, but go over to Judge Stevens.
Speak out so she can hear you. Thank you. Speak, sir.
Oh, yeah.
Yeah, there you go. Okay. You were charged here with two cases, 25 CR 374 and 494. 374 is a state jail felony of allegation of fraud on or about February 15th, 2025. You was intentionally and knowingly using identifying information, that is credit card numbers and Lone Star account numbers, without the consent of the rightful owner. A state jail felony, if convicted, carries with it up to 2 years in the state jail. Joseph Lewis. 25 CR 494 charges you here with more serious punishment range here. In paragraph 1, this alleges that on or about March 5th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of harassment of a public servant, which would carry with it up to 10 years in prison if convicted. But this has a second paragraph, which states that you were previously convicted of assault on a peace officer and punished in the convicted in the court next door, the 252nd District Court in 2023. So if you were found guilty of this 3rd-degree felony, it gets enhanced if that prior conviction is indeed valid. And thus you would be looking at a 2nd-degree felony, which is no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 would be assessed. If that prior conviction is true, you're not eligible for probation in either of these cases in front of a jury. About right? Correct. All right, what are we doing on this?
He wants to plead not guilty, to set for trial. He's asking that I be replaced for this on the docket.
Okay, is that right, sir? That's what you want? Okay, there's no deals. We're going to go to trial. There are no deals. This was your chance, and I find good cause to replace Mr. Dusler. The next attorney on the trial docket deal will be brought forth, and we'll try that case. There are no deals on this, and tell that person, whoever we hire, it's going to be fast tracked. Get this to trial as soon as possible. Next, that is on Kenneth Wiley. Kenneth Willie, I mean.
Yes.
So, well, I haven't seen this one.
Is Charles Floyd, Mr. Floyd?
Sure, he's not yet.
You mean, okay, we're going to call you up next on James Van Wright.
Yes, sir.
You're in the queue. Thanks. You know, he was declared competent.
Yes.
Yeah, okay, you got it. All right, Mr. Willie, that's you, sir? Okay. And cause number 23 CR 752. As you know, you're charged with 3rd-degree felony of escape. And that carries with it up to 10 years in prison. There's a prior conviction, it is alleged, here out of Newton County, Texas in 2000, which interestingly enough, you were convicted of the 1st-degree felony of escape.
Yes, sir.
And so this 3rd-degree felony and this prior conviction together will enhance to a 2nd-degree felony punishment. So you're looking at up to 20 years in prison here. And you're obviously anxious for a speedy trial. You wrote something to me. You want a speedy trial. And certainly we'll do the best we can do to get, we tried 600 cases here. So we're doing as fast as we can. So anything changed other than?
No, sir. He'd
the
like
last?
to be set for trial and have me replaced and get the court.
All right, then I find good. Yeah.
Is there any possible way I can get it out where you just, I'll sign for 10 if it's ranked concurrent with the orange that I'm doing right now?
Well, I'm not the guy that you deal with.
That's the offers that's been made, Judge. It says it's been, I've offered 10 years.
Okay, so that's what I was trying to look at, but is there any possible way I can get the escape lower? So I don't do the.
That's y'all, that's for y'all.
Possible.
That's for y'all. But there's the offer that they're making. If
That's
That's
what
what
it
you,
is, but I'm not changing the offer.
and it would run concurrent.
Okay, so.
But I mean, unless there's something happens with the other jurisdictions, but I don't have a problem.
Yeah.
Let me know when you're ready. Thank you. James Van Wright. Yes, sir. I'm listening. Looks like we got 2 cases here, James, on, I'm sorry, Mr. Floyd, on James Van Wright, James Van Wright.
He's not taking the deal. He's, if he doesn't pay for it. Yeah, it's your responsibility to get the paper.
Yeah, well, they'll help you. It's the hand working.
I'm sorry.
Mr. Van Wright, is that you?
Yes, sir.
Okay, and you were here with Mr. Floyd, your attorney?
Yes, sir.
Stand up. So what are we gonna do? Yeah, we're moving this thing today?
We're gonna, he's gonna accept the plea.
Okay, what is he gonna plead to both, or is one gonna be dismissed? What's the
The
plan?
offer is 10/10 probation, $500 fine on each case, Judge.
Okay.
Based on the mental health history, he'll be placed on the mental health case law.
All right, we'll write it up and get the man out of here.
Sounds good.
Okay.
Thank you, Your Honor.
Thank you. Yeah. And David, well, Ben,
Let's go over to Judge Boyd. She had a look on her face like she's about ready to lecture somebody.
Just tell you what's going on. You're being rude and disrespectful to your probation officer. You act like you're not on probation. When I say there's to be no contact, there's to be no contact. And now you're using profanity towards probation officer like you're not on probation and that this is somehow his fault. It is not. It's all your fault. You're here because you're on deferred adjudication for injuring someone who's an elderly person. That's why you're here. You're not on probation because he placed you on probation. You're not on probation because he committed a crime and you're taking the time for him. You're here because of your actions and you're acting as though none of this is your fault. This is all your fault, 100%.
I'm not acting like none of this is my fault, and I take accountability for what I've done.
No, you have not taken accountability. Did you take accountability for using profanity towards him?
No, I didn't.
And I don't know why people think that when you're in a situation where you should be using logic to find what are using your cognitive skills to decide how I'm going to proceed with this, instead, you go after your probation officer. And the probation officer, let's be honest, every defense attorney will tell you a probation officer holds your life in their hands. Because you know what? Let's say you're supposed to report to probation at 9 a.m. and you end up reporting at 9:05. Guess what? You have not reported at 9 a.m. A probation officer can say, hey, that's a no report. But sometimes they may take sympathy on you and say, I realize what's going on. They're here. But they don't have to do that.
Yes.
And you using profanity towards a probation officer is not helping your case at all.
And I understand that. And the reason why I did, and I just said the F word because he called me a liar. And when I didn't lie to him about any situation that was going on, I sent them all the information from my legal aid lawyer. I sent them everything. He even gave me his personal number for me to contact him. When I had to go to the emergency room and had to get a blood transfusion, he even offered to take me there. He called.
This is not your blood. This is not about your blood.
I know it's not about my blood, but it's he basically, when I went to go see him, he was telling me that I lied to him, which I never lied to him about anything.
No. This starts with you wanting to go to a location where I said you are not allowed to have contact. That's where all of this came up. Then everything snowballs into something else.
Yes, ma'am. And I did exactly what you told me to. I didn't go to that location I filed my police reports. I did everything that I could do without going to that location. I
All right,
have,
so then that was it. I don't know, what do you expect him to do? Like, I like for people to just put their cards on their table. Sometimes people are like, judge, but I like everybody to have an understanding. So you go to him because you want to go to a location and retrieve items when I told you you couldn't go to that location. So we're back to the point. What did you want him to do?
I asked him, was there any assistance or any way that I could? He told me, I don't know. He told me he didn't know, he couldn't help me. So I didn't have no other choice but to call the police, make a police report. I had my daughter, she's 16 years old, to go there. When she went there, she took pictures of everything that was outside.
All right, so again, what did you want him to do? He said, hey, I don't know, there's nothing I can do for you.
When I contacted Miss Adams, she told me to ask my probationer if there's any assistance that he can help me or provide without going to that location.
And he's saying no.
And he said no. And I told him I don't have no other choice. My children is 16 and 18. They didn't have the money. They don't have money for you all. My daughter just quit her job because no one was able to take her to work. So I didn't have nobody else to help me get
So
anything.
again, I don't know how this translates into you using profanity against him. He's like, I can't help you. And honestly, it's not his job to help you get your things. Really, you know what a probation officer's job really is? And they'll correct me if I'm wrong, but their job is to make sure that you abide by your conditions. Everything else that they're doing is just extra, but that's not their job. It's not, for example, if you can't pay your utilities, it's not their job to find places for you to pay utilities. They'll do it. They'll say, here's some places that you can call. But that's not his job. And if he tells you, I can't help you with getting your things, again, we're back to the point. He says, I can't help you. So what do you want him to do? He's like, I can't help you.
And
how does that translate into using profanity against him? And then telling him, sending him an email, telling him all this is his fault and it's on his shoulders. It's not. All of this happened because of you. Guess what? You can't go to that location because you injured an elderly person. That's why it's all your fault. And there are consequences for all our actions.
It is. And I communicated with him. I told him everything. I sent every case number. I even sent him my legal aid information. I sent everything. I tried to do everything the right way before it even went out of hand.
But see, here's what you don't understand, and you're not internalizing what I'm saying. He is telling you, I can't help you with that. And you still keep going back to him. He's already told you, I can't help you with that. Giving him numbers to your legal aid, giving him numbers to this person saying, we're trying to help her get her things. He can't help you with that. His whole role is to supervise you on probation. That's it. He can't say, you know what I'm going to do? I tell you what, let me go over there and get your things for you. He can't do that. That's not his job. Now, if he offers to do that, great, but he doesn't have to. He has told you more than once, I cannot help you with that. I still don't understand how that goes and translates into you using profanity against him. His job is hard as it is. And then to have somebody come in and use profanity against them, that's an issue. And then to have you go into that location when you know you're not supposed to, that's an issue.
I never did go to the location. I didn't. I had to call the police from a different location.
All right, so you called the police and then what happened?
I made the police report. I went down to the property. I also went down to 315, the headquarters, to fill out all the information because the day I was arrested, everything was stolen. My car, my credit cards, everything. So I'm trying to do everything that I have to do the best way that I can, the right way.
All right, the right way is not using profanity against your probation officer. That's not the right way. The right way is not being disrespectful. And you know what? This whole thing with the injury to the elderly, where I ordered anger management, you do have an anger problem. Because when people tell you no, you can't accept that, you take it to 100. He said, I can't help you with that. And then you use profanity against him. You're calling him all sorts of names. Nobody likes to be called out there, give a name.
I didn't call him out his name. I just said it was fine. I didn't have no other choice, so I would have to figure it out.
No, we're not here because you said it was just fine. Where is the officer? I could come forward, please.
And I'm just like,
All right, so you're Officer Wolf?
Yes, ma'am.
All right, so let me ask you a question. Are you able to go to her former location and get her items for her? No,
No, ma'am.
that's your answer, no. Are you able to file a police report for her so she can get her items?
No, ma'am.
So he can't do that. So what do you want from him?
I have to do it on my own, so if there's something he can help me with, and then that's.
Well, see, that's the thing. Now, when you're before me and you're looking at potentially going to prison, now you're like, oh, well, he can't help me with that. He's told you that. Be an adult, solve your own problems. This is supposed to be problem solving. That's why you're on probation, for anger management issues, because you can't problem solve. I don't know, maybe you never were taught to problem solve, but if he's telling you, no, he can't do that, that's not in his job description, then there's no need to use profanity against him. He's told you, I can't do it.
Judge, if I could.
Yes.
Speak for a minute. Throughout my time working with Ms. Holmes, it's been pretty apparent that she has a pattern of not taking responsibility or accountability for her behavior. This last incident just kind of made it painfully obvious how there's a deeper issue.
Mhm.
There's a heart issue. Until she can get her heart right, this pattern of behavior is going to continue for her throughout her life.
Mhm.
And she's going to continue to be a danger to herself, to the community, to her victim, everybody. She needs to get her heart right and realize that choices and actions have consequences, good and bad, unintended and unintended, anticipated, unanticipated. And until she gets her heart right and realizes that this is just going to continue.
All right. Thank you so much. And thank you for coming down.
Yes, ma'am.
So you're going to have to start using your cognitive skills and your problem solving. That's it. When somebody tells you they can't do something, then they can't do it. If somebody tells you, no, I can't take you to the grocery store today, figure it out. He is not really responsible for anything outside of his job description. If he does something outside of his job description, that's just probation officers being nice.
And I understand that, but why would you offer to try to help me when I'm asking for some type of help, and then you tell me you can't help me?
Yeah, he said no. Let me just tell you, here's a perfect example. And I've been in situations where people have told me no. And my thing is, I want you to not send me place to place. If the answer is no, just tell me no and I'll figure it out. He told you no. If I ask him right now, like for example, I had to rush here this morning because I don't like being late. And I was filling in for somebody else on another matter. And guess what? My tank is at a fourth. I don't like it being at a fourth. Now, would somebody go, excuse me, could you go and put gas in my car for me? They're going to say no. Now, what do I do with that? Do I use profanity against him? How dare you not go put gas in my car? He's just told me no. So guess what? As an adult, I got to figure it out. That's it. You got to figure it out. And your figuring it out is, let me get angry with somebody and use profanity against them. And maybe they'll then become so afraid of something and say, okay, we'll do that for you. Not his job. And I can tell you right now, if you don't start treating people with respect, one, you're not going to get anywhere, because when you disrespect people, they don't want to help you. And number two,
respect.
No, you did not. That's the thing. You're still in this clouds. Like these are not, I don't know how your relationships are outside of this world. But in this world, you need to treat people with respect, whether you respect them or not. Like right now, you can hate my guts all you want to, but you had better say Your Honor or Judge. You understand? You better not be calling me out of my given name. And you better not be calling probation officers out of your given name. I'm sure he told you, no, I cannot help you. And when somebody says, no, I cannot help you with something, maybe you want to ask them again. You ask them again. If you ask the third time, you're begging. And he's already told you he can't help you with that. That is not his job. That is outside his job description. If he decides to help you outside of his job description, just him being nice. You need to figure it out. The same way people have children and you figured out how to have children, you need to figure out how to get the rest of your life together. You're on probation because of your actions. And honestly, the reports I received, I will tell you, when I received that report, I told them, file a motion to revoke. And then probation came to me and said, Judge, could we do a compliance hearing to have her come in? And I'm like, yeah, if you all want to do a compliance hearing, we will do a compliance hearing. So this is the last time I'm having this conversation with you, telling you, you need to be respectful to people and you need to learn how to problem solve. How old are you?
33.
You're 33-year-old. You figured out how to get all of those piercings, right? You figured out how to get the nails. You figured all of that out on your own. You need to figure this out on your own. Is there anything else you need from me?
No.
All right. Does she need to, when is her next report date? Are you employed?
You told me I had 30 days to find a job. I had a business, but all my stuff is gone.
All right, so that'll be a no. So Miss Ferguson, recall her for the week of August 11th, and I'm going to see how you're doing on probation. What date?
I can do that. That's my date, the 11th.
All right, so you're coming back on August 11th for me to get a report on what's going on. If you'll give her a reset form. Probation,
Yes, Judge.
when is her next report date with you?
It's not, I have an appointment set right now, from Officer Wolf's information, she was supposed to be reporting.
He wrote on the paper, July 9th.
Twice a month.
July 9th?
That's what he wrote on the paper.
All right, so she said her next her next appointment date with him is July 9th. All right.
I have to confirm, Mr. Wolf was mentioning that the GPS is supposed to have been installed as well, but that she did not have it.
All right.
I don't have nowhere to stay, no address.
It was ordered June 5th. And it was supposed to be done through work release waive the fees for partial for employment purposes only.
All right, so if you all could give her a list of places for her to find housing. And then we're going to come back on August 11th. And by August 11th, you need to have the GPS on. All right, thank you. And the persons who are here for the VTC, please. And Norma, if you'll make sure she gets that reset form, please.
Yes, ma'am.
Yes, please. Sorry, I'm just putting something in very quickly.
Ms. Holmes, Loretta Holmes?
Okay, yes. So on, let me see. Okay, well, she knows she's supposed to be here. All right, so on this case, yes.
Morning, Judge.
Good morning.
So the next date we have scheduled to review folders is gonna be July 31st. Only
Okay.
day after that, we should have an answer for it.
All right, so, and he'll be in for July 31st?
July 31st is when we're gonna review, Judge, so if you wanna bring him in that following Friday, we should have an answer for by then.
Okay. All right, so you'll need to make sure that you keep in contact with him. You have their information?
Yes, ma'am.
All right. Ms. Ferguson, can you reset this for the, do y'all want to do it? Are y'all okay with doing it maybe the second week in August? That'll be
time, that may give you time to review in a second.
the week of August 11th. Is that good for you
That's
guys?
first, Judge.
All right, Ms. Ferguson, if I can have a reset date for the week of August 11th, please.
I can do August 12th.
August 12th, is that good for everyone?
Yes.
All right, once you sign the reset form, you're excused.
Thank you.
Thank you, you're welcome.
Morning, Judge.
Good morning.
For your signature, a couple of vouchers. Thank you very much.
We haven't been to Michigan yet this morning, which is weird. So let's go to Michigan and we'll say good morning to Judge Dad.
You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Okay, go ahead.
On 3/26/24, at approximately 14:26 hours, officers Nicholas Mitchell and Edward Cash with the Woodhaven Police Department performed a traffic stop at northbound I-75 and Vreeland Road inside the city of Woodhaven, Michigan limit. On the defendant, Christopher John Henthorn, officers observed Henthorn was on his cell phone and driving in his hand. Ultimately, Henthorn was arrested on probable cause for being in possession of narcotics that was found inside his vehicle during the traffic stop. The United States Border Patrol K-9 unit and handler Agent Sean O'Donnell performed a free air sniff of the vehicle. The K-9 displayed a positive indication of suspected drugs inside of the vehicle. Officers then searched in the vehicle and found multiple baggies of suspected drugs along with drug paraphernalia. These items were confiscated for evidentiary value and later submitted to the Michigan State Police Laboratory for analysis. Defendant Henthorn was released pending the lab results. The Michigan State Police Laboratory later report revealed two of the evidences that were collected as suspected drugs tested positive for narcotics. One of the items tested positive for cocaine in the amount of 5.18 grams, and the other tested positive for methamphetamine in the amount of 23.83 grams. A digital scale with white powder residue was confiscated as evidence from inside the defendant's vehicle, along with $592 in cash in his wallet. That was also collected as evidence for probable cause for possession with intent to distribute.
You have this prior conviction of August 28 of 07 for home invasion second.
Are you asking me, do I have that in front of me at the moment?
You have that. You have his criminal history. Does that show a conviction on that date? Again, it's August 28 of 07, home invasion second, because they're charging habitual second here.
Yes, that is correct.
Now,
I've got a CCH.
Go ahead. Go ahead.
August 22nd of 08. Pretty lengthy here.
I'm looking for the home invasion second on August 28, 07, unless that's an incorrect date.
I'm not seeing it on my copy of the, of his, CCH. I should probably run it again. This was ran.
You have a home invasion second conviction somewhere on there. Yeah, I'm looking at it. It's got August 2807, home invasion second. The rest of these, for the most part, appear to be, I don't know what, there's no disposition on a UDAA, but I'm going to authorize, except I want to ask you a question. You said this occurred March 26th of 24. The complaint alleges March 26th of 25. Which was it?
If I said 24, I stand corrected, 25.
Okay, good enough. Based on your sworn testimony, I found the crimes: possession with intent to deliver less than 50 grams of cocaine, possession with intent to deliver methamphetamine were committed. Those are 20 year, and then you have a second offense notice giving rise to the habitual second. I'm going to authorize on both the complaint and the warrant on those charges. You are all set. Thank you very much. Have a good day. We'll put that in lien.
Thank you.
Thanks. Do we have Brownstone coming in?
She's been contacted. They're waiting to clear the booking room.
Concord versus Antoinette Harris. Do I have Mr. Mayers in here? Jennifer?
All right, we're going to move on from Judge Dad because the other stuff he's got going is all civil kind of stuff, which, you know, is, why aren't you paying money? And they go, because I can't. And then everybody goes, okay. And then they move on. So we don't need to watch that. Let's go back to Judge Boyd.
No problem. You're welcome. Okay. Yes, counsel.
I received a plea offer this morning, Judge, from Mr. Garahan. We just need a plea deadline date from the court.
All right, sir. How old are you?
44.
All right, Ms. Ferguson.
Yes, ma'am.
You set this for a plea deadline date the second week in July, please?
Yes. Keep the bond.
Is that a good date for you, counsel?
It should be, Judge.
All right, your plea deadline date will be July 10th. At that date, you need to let me know whether or not you've reached an agreement. If you have not, then your next setting will be a trial setting, okay?
Yes, sir.
All right, thank you. Have a good one. Once you sign the reset form, you're excused.
Yeah, thank you so much. Just have a second. Thanks, Judge.
You're welcome.
Judge, I have one more case in your docket.
Yes.
But I'm gonna run to the 175th and I'm gonna pop back up.
All right, thank you.
No, because I'm gonna go to 175th. I'm going to trial.
Who's on, Ted Kalunga?
Right here, Judge.
All right, if you all would come up, please. Hello. So counsel, you have all of the discovery?
Not quite.
What's
and,
missing?
I believe we're missing some medical. And I'm also provided discovery this morning to the DA. And they're going to follow up on what I provided them. And that might resolve this case.
All right, what's the medical holdup?
I don't know. No, I think it's hospital records and there's a civil lawsuit going on, which I think is tied things up, Judge. I know there's a civil lawsuit.
Okay. Ms. Ferguson,
Yes, ma'am.
can you put this at the end of July for final discovery, please?
Yes, ma'am. I can do, July 28th.
Thank you, Judge.
All right, that will be your final discovery. Once you sign the reset form, you're excused. Thank you.
Reminder to everybody as we're approaching the top of the hour that we are adding a third hour today. So, batten down the hatches. Let's go back to Judge West.
Number one.
Good morning, you're Ashley Sanders, and this is 241650. Ms. Sanders is charged with theft of service, and Mr. Kelly, what is the announcement?
Judge, if I may, the court has been very,
Kelly, what is the announcement?
Judge, if I may, the court has been very gracious and lenient with us in resetting this and trying to obtain a forensic audit. We reached out again this morning, let them know they have a date certain that we must have it by in case would likely be dismissed. They were made aware of that before court this morning. If I may just have that one final, say last reset, I won't ask for it.
Okay, all right, any issues?
No.
I'm sure you're from that. Okay, we'll do one last final reset. Stay in touch with Mr. Kelly. He'll let you know when you need to be
And
back.
of course, if I do in fact get that, Judge, I will turn it over immediately.
Perfect. Thank you. Y'all are free to go. Mr. Lewis, you have Shy Brooks. Good morning. Good morning. You're Shy Brooks. And this is 24-2034. Mr. Brooks is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
Judge, I've talked to Mr. Brooks. Evidently, he had my incorrect contact information. We've taken care of that this morning because there is some media that I received in relation to this case. I need to go over with him.
Okay. So, Mr. Brooks, I'm going to reset your case one more time. It's important that you make sure and call soon so that you can get an appointment to go see Mr. Lewis and go through all that information, okay? All right, we'll see you at the next court day. You're free to go.
Thank you.
See, Mr. Crenshaw, you have Guillermo Galvin.
Yes,
Good morning, sir. Are you Guillermo Galvin? And this is 24-2321. Mr. Galvin's charged with driving while intoxicated, third or more. And what is the announcement?
Judge, this will be a plea. We just need to get him a scram device to show the prosecution that he is correct in his statement that he is no longer drinking. And so if we could have a 60-day reset, just because we need to
30 days. This has been since January, and we're getting close now to end of June. So we're going to do a 30-day reset, get that on as quickly as you possibly can so that she can get some of those results. Let's just see where we are at the next court date. All right? Okay, sure. Thank you. All right, you're free to go, sir.
Let's go back to Judge Glazer, where it seems in Miami the suicide smock is back in fashion.
He removed the board out of his backpack and began yelling, "I hate this blah, 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 blah church," because that's X-rated. I can't repeat that. Okay. He was asked to leave the church. He refused, and he said he's going to hurt and mess you up. All right. So he disrupted the religious service. Witness 3, who was identified as Ting Ting, said she was playing the piano during the worship service when he entered the church yelling. He doesn't recall the exact words spoken, but confirmed he was wearing a black ski mask. And she'd seen him before. It's not the first time of an incident involving him. So, all right, sir, I'm ordering that you stay.
I only did the park. You should stay away from the church too.
Let me write this down. You were ordered to stay away at the top. I'm sorry. I have to get the name of the church. What's it called?
Tibor and Sheila Holo.
Park. We need the church's name. I just had it.
Oh, that's the Parker.
Just read it. Give me a second. Emmanuel Lutheran Church. You're ordered to stay away from the Emmanuel Lutheran Church. We need to confirm the address of that church. Can you have it, Miss Al? You're faster than me.
I can try. I think it's the 1770.
70 Brickell Avenue in Miami, Florida. You're not allowed to go to that location. You must stay away from there, sir. Do you understand? You cannot go into that church even to pray. They don't want you there. Okay. And then, name of the, I'm sorry, I need to get the address now of the park, because that's not the right address, I don't
The
think.
part, oh,
That's at 1814 Brickell Avenue. Also stay away from the Tibor and Sheila Hollow Park at 1814 Brickell Avenue in Miami, Florida. You're not allowed to go to that park either. And also stay away from the alleged victims, Christian Daly and Winston Leach. No contact with the alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victims, their home, school, and place of employment at all times. So give me a second. Let's set the bond on the first one. F25 12966. So he's charged with battery and assault. I'm sorry, I missed the battery. I don't see where the,
I want to hurt you and mess you up, but that's just words.
I don't see battery, maybe 2 assaults.
Okay.
So count 1, disturbing a religious assembly. I don't know, is there prejudice?
No prejudice.
Was that a 3rd-degree felony or misdemeanor?
I think, well,
Third-degree
it's charged
felony.
as an F2, so it would bump it to an F3.
I'm setting that bond on count 1 at $5,000. It's a 3rd-degree felony. Count 2 and 3, there's probable cause for an assault. It's $250 bond for count 2. And actually, I'm gonna set count 3 at $500. He's wearing a mask. I don't know if that's why they made it. Should it be with a mask?
I don't know if there's a mask enhancement for that charge.
Actually, I'm making count 2 for $500 and count 3 is $500. Count 4 disorderly conduct is $150. Then the next case, F25 12963. I need to read this. All right, so let's see. Is it 11 o'clock? The victim's at the park with his 2-year-old. He sees the defendant sitting on the bench. They walk towards him and told him he left the park's gate open. He's not supposed to be in the park without a child. The victim standing next to his child. Let me see. Defendant stated to the victim, give me $500 or I'm going to mess you up, and stood up. The victim in fear walked away from him. I guess there would be probable cause for an attempted strong arm robbery. That bond will be $5,000 as well. All right. Good day, sir. Next is Roy Owens, page 10. Is he here? Is he refusing?
It's here, Your Honor. Over here, Mr. Owen.
Good morning, sir. You are arrested for aggravated assault with a firearm. I will appoint the public defender's office for you.
I never had a firearm. They handcuffed, I asked for attorney 30 times.
Okay.
They never gave me an attorney to call.
Stay
I
away
was-
from victims Alvin Fuentes and Marco Ruiz, the roofers, who are there to work on the roof. No contact with those victims, either directly, indirectly, in person, in writing.
I told them,
or through third parties, and you must stay at least 500 feet away from their home, school, and place of employment.
attorney, Robert Hall, 30 times and y'all would not give it. They kidnapped me. They first grabbed me, aggravated assault with battery. They put handcuffs on me. That's kidnapping. And then they human trafficked me when I hit the sidewalk. And I was human trafficked all the way to DGK. The people that they spoke to, I went to I was going next door because they put a unlawful roof on my mother's home. I did not have a gun. They have a stun gun. I had a stun with a recording
about this.
I have a
Thanks for admitting the charge. $5,000 bond.
I'm on a federal.
Approve the
I'm on a federal.
He said he had a stun gun. Just help the state prove its case. Okay, next is Luis Gonzalez. Page 10. Good morning, sir. Do you speak English? Sir, you were arrested for aggravated battery on a person aged 65 or older. I will appoint the public defender's office for you.
Judge, if you're honored, give me a second. Let me see if I can get the officer on.
Take two. It's only 10 past 12. We're no rush today. Although I do have an appointment to go see if there's any mullet's or manatees at the river. Well, at least I can make you laugh. Okay. Give the date with the date to see the birds fly by and the chickens. I gotta see if there's any chickens outside. New baby chicks.
We can reset it for PCH, no answer.
Let me just review this real quick.
Your Honor, there's no age of the alleged victim on this arrest form.
It just asked me to reset it in the afternoon calendar for a probable cause hearing. All it alleges is that Mr. Gonzalez grabbed the victim by his chin, turned his neck, and cut him on his neck with a knife while the victim was washing his car outside a Taco Bell. So there's only probable cause for aggravated battery. So we got to find out the victim's age. We're resetting it for the afternoon. Also, sir, you are ordered to stay away from the alleged victim, Ricardo Ugaz. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. So we're resetting it for a probable cause hearing. We'll see you later. Probable cause for the F2 aggravated battery. Although per se, it may be an F1 if he cuts somebody on the neck with a knife. I don't know. We'll argue that later. See what happens. Now we have Rolando Macera Molina, page 11. Good morning, sir. Or good afternoon, sir.
He has a hold for immigration.
You speak English? Habla inglés?
No, Spanish.
Yes, se les intérprete.
You were arrested for battery on 4 counts of battery on a law enforcement officer and 1 count of resisting an officer with violence.
Señor, le han arrestado por 4 cargos de agresión física contra agentes del orden público y un cargo de resistir a la autoridad con violencia.
I will appoint the public defender's office for you.
Voy a nombrar a los abogados de oficio que lo representen.
We slapped and kicked 3 firefighters.
Le dio bofetadas y patadas a 3 bomberos.
He also punched Sergeant Vicin when he came over to assist the firefighters. He punched him on his face.
También le dio un puñetazo en la cara del sargento Vicen cuando el sargento vino a ayudarle a los bomberos.
So there is probable cause for the charges, all the charges.
Hay motivo fundado para los cargos, todos los cargos.
Your Honor, I have actually a PC argument where the arrest form states that he aggressively resisted by flailing his arms around, and that through that aggressive resistance, 3 firefighters were hit. And then there is the 1 punch, closed fist punch. So it seems to me like there's 3 resisting with violence and 1 battery.
Su abogada de oficio dice, juez, dice aquí,
Oh, they were firefighters, Your Honor. Apologies. Misread that as if they were officers.
No, we got this one and one more.
su abogada dice que sí, tiró los brazos al aire y por eso le logró pegar a 3 oficiales, a 3 bomberos y uno que le dio el puñetazo. Así que son 3 de resistir con violencia y una agresión física.
So we're clear. Did he have an immigration hold?
Yes, Your Honor.
¿Tiene orden de retención
she
de
has a
inmigración?
nice
Sí.
Yes, Judge, she has a nice home.
Okay. So, counsel, it says here, he flailed his arms and slapped and kicked a total of 3 firefighters.
I understand, Your Honor, but just with the way that the arrest form describes it, that he was unconscious, unintelligible, and that he was being physically put on a stretcher, to me, it seems like his intention was to resist, but maybe because of, again, as the allegations state, because he was intoxicated, that resistance became violent and resulted in these people being hit. But again, I don't know if there's any difference between resisting with violence or if you can resist with violence with a firefighter. So then there would be PC. But still, I only see 3 individuals, not 4, who were battered and then 1 resisting with violence. So at least.
Abogada, aquí dice que estaba tirando los brazos al aire o le golpeó a los oficiales. La abogada contesta sí, pero lo que digo es que tal vez no fue intencional resistir a la autoridad, sino que no estaba consciente, no fue intencional, lo estaban tratando de poner en la camilla, es por eso que podría ser resistir, y aquí yo veo que son 3 y no 4.
So there is probable cause for 4 counts of battery on a law enforcement officer / and firefighters.
Hay motivo fundado para 4 cargos de agresión física contra agentes del orden público y bomberos.
Slapped and kicked 3 firefighters and also punched the Miami-Dade Sheriff's Officer Sergeant on his face.
So, Your Honor, is he being charged with resisting the officer and battering the officer?
Interpret before you speak.
Okay.
Entonces, dice aquí que le dio bofetadas y pateó a 3 bomberos y dio un puñetazo a uno de los bomberos, de los sargentos.
Yes, please go ahead.
So to clarify then, 1 of the counts for each is for the same officer.
Quiero aclarar, uno de los cargos por cada uno es contra el mismo oficial.
Okay, let me see this again. Say it one more time and I'll read it slower.
So I see 3 firefighters.
He slapped and kicked a total. Total means there were 3 firefighters on the scene. So he slapped and kicked 3 firefighters here and the 1 sheriff's deputy, and that is a total of 4 law enforcement officers.
Deje leerlo más lentamente. Aquí dice que le dio bofetadas y pateó a 3 bomberos, 3 en total, y a uno de los diputados del sheriff.
And he's only charged with 1 resisting because usually that's all they do is 1 resisting an officer. That's all they charge with.
Y solo le están acusando de un cargo de resistir a la autoridad porque usualmente eso es lo que hacen.
Do you have another question or argument you'd like to make regarding probable cause?
No, Your Honor.
¿Algún otro argumento sobre motivo fundado? No, juez.
When did he enter the country? He has an immigration hold.
¿Cuándo entró al país? Tiene una orden de retención de inmigración.
No information.
I'm setting a bond, counts 1 through 4, battery on a law enforcement officer is $5,000 each count.
Voy a programar una fianza del cargo 1 al 4, agresión física contra agente del orden público, $5,000 por cada uno.
Count 5, resisting an officer with violence, I'm setting that at $5,000.
Cargo número 5, $5,000, resistir a la autoridad con violencia.
$25,000 plus he has the immigration hold. Good day, sir.
$25,000 de fianza más la orden de retención de inmigración. Buen día.
Camaleras, page 12. Good morning, sir, or good afternoon. Do you speak English?
No.
So you were arrested for improper.
He needs an interpreter, Your Honor.
No, we just.
Judge, this is Mr. Sandoval, who we passed.
Sorry. Okay.
He also has a hold for immigration.
Also needed a Spanish interpreter. Okay, good morning, Mr. Sandoval, on page 9.
Buenos días, Sandoval.
You were arrested for one count of attempted second-degree murder and one count of aggravated battery.
Lo han arrestado por un cargo de intento de asesinato segundo grado y un cargo de agresión física con agravantes.
I will appoint the public defender's office for you.
Voy a nombrar a los abogados de oficio que lo represente.
So the victim was stabbed and had to go to the hospital.
La víctima fue apuñalada y tuvo que ir al hospital.
He had an argument with the victim and pushed the victim and tried to knock him to the ground, but was unsuccessful.
Hubo una discusión entre él y la víctima, lo lanzó hacia el piso, trató, pero no logró.
So the victim pushed him to the ground, and then Mr. Sandoval's armed with a box cutter and begins to stab the victim numerous times in his torso area.
La víctima empujó al señor tratando de tirarlo al piso, entonces el señor sacó una navaja y lo apuñaló múltiples veces en el área del torso.
The police found 2 retractable folding knives at the scene of the crime.
La policía halló dos cuchillas retractables en el sitio del incidente.
State is it an aggravated or an attempted murder? You charge him with both.
Fiscal, ¿es agresión física con agravantes o intento de asesinato? ¿Usted lo acusan de ambos?
One's a lesser
Of the other.
of the other. So the state's requesting the Your Honor find the higher charge.
La fiscal pide que haya motivo fundado para el cargo más grave.
The victim had several lacerations to his left arm, face, and torso, so he had extensive injuries.
La víctima tuvo lesiones considerables al torso y a su cara, lado izquierdo, y su brazo.
Your Honor, if I may, I understand the state's argument for why the higher charge and your concerns for the injuries, but there is some evidence that there is a mutuality, or like the arrest form describes the defendant being on the floor with the alleged victim on top of him. So I feel like that changes the circumstances a little bit, and I would argue for the PC to only be for the aggravated battery.
Pues se podría alegar que es un combate mutuo, que si el señor se encuentra con la presunta víctima encima de él, entonces eso cambia las circunstancias un poquito. Yo alego que solo es agresión física con agravantes.
There's probable cause for attempted second-degree murder,
Hay qué motivo fundado para intento de asesinato segundo grado
as well as aggravated battery.
y también agresión física con agravantes.
Order to stay away from the alleged victim is Smar Lima.
Se le ordena que se mantenga alejado de la presunta víctima Ismar Lima.
Contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No contacto con la víctima ni directo ni indirecto, ni en persona, por escrito, por teléfono, ni a través de terceros.
And no contact with the victim through social media or other electronic means.
No contacto con la víctima a través de las redes sociales o ningún otro medio electrónico.
You must stay at least 500 feet away from the victim, his home, school, and place of employment at all times.
Permanecer en todo momento por lo menos 500 pies alejado de la víctima donde él estudia, vive o trabaja.
Count 1, I'm granting the state's motion for pretrial detention pending final hearing, holding you at no bond.
A cargo número 1, voy a conceder la petición de la fiscalía deteniéndolo hasta el juicio para una audiencia antes del juicio sin fianza.
Count 2, the aggravated battery, I'll set it at 7,500.
Y cargo número 2, agresión física con agravante, 7,500 será la fianza.
Judge tomorrow, and I believe you said he had an immigration hold, so he has that too. Good day.
Entonces será para mañana y creo que tiene una orden de retención de inmigración, anunciaron. Que tenga buen día.
All right, next case is Armando Tamaleras, page 12.
He's Ward D, Judge, reset.
Ward, do you want to waive his presence? Otherwise, it's going to keep printed. He's held on something else.
Okay, Your Honor, we can waive his presence.
All right. So it's bond's $2,500. Let me see what he's.
Well, let's hope she gets her lunch break soon. We'll maybe come back after that. Let's go back to Judge Stevens.
Yeah, nobody likes being interested.
Well,
That's bad.
also the new drugs. And that right there.
Okay, we called, two cases here, 24 CR 1056 and 25 CR 491. The state of Texas versus Chardarian Parker, you and Mr. Parker. Present with Mr. Grove, your attorney, and the state's attorney. The defendant has entered a plea of guilty to the aggravated robbery, correct?
Yes, sir.
24 CR 1056. And then this aggravated assault with a deadly weapon is to be dismissed as part of this agreement, correct?
Yes, Your Honor.
Is that right? That's what I understood. What was the date? 5/12. Wait for her to get back. Earlier in this case, the defendant entered a plea of guilty to aggravated robbery. A pre-sentence report has been prepared. And have the parties had an opportunity to review it, and are there any corrections or changes? State
No, Your Honor.
and defense.
No, Your Honor.
I can't find Chardarian Parker's plea. It says the plea was entered on 5/12. There's nothing showing up on this screen. Can you pull it out and let me look at it real quick? Thank you. So if the agreement is a cap of 8 years in prison, what we're looking at is two options. No less than 2. No, stand by. It's a first degree felony, correct? No less than 5, no more than 8 years confinement in prison, or deferred or unadjudicated probation is an option. Regular probation is not available under the indictment, which alleges a deadly weapon, namely. All right, go ahead, Mr. Grove, you may go first.
Yes, Your Honor. May it please the court.
Yes.
And looking at Mr. Parker's record in this particular case, I hate to say it, but he may be one of the more fortunate people, even though he is charged with and has pled guilty to an aggravated robbery in which there were 3 individuals that went into a convenience store, and Mr. Parker had a handgun. There were no shooting. No one was really, in fact, even pointed the gun at them, but it's a very serious offense. And we look back at Mr. Parker's criminal history. The first thing that I see in looking at his entire criminal history and other background is he is probably one of the few individuals that I have ever seen in front of this court that does not have any drug charges, convictions, or probations, which is very unusual as the court goes. And I think that it's something, though, that will help Mr. Parker as he goes on with his life, in that he doesn't use drugs. What he is, the other thing in this case, look at the age of the 3 defendants. Mr. Parker has no prior adult convictions. He has actually two probations as a misdemeanor, or juvenile rather, but no drug charges and nothing like that. He also almost made it through high school. He dropped out when he was in the 12th grade, but this sets him up, and he's planning, if the court allows him, to go back and get not just a GED, but a high school diploma from his high school. And that's worth, in my experience, a whole lot more than a GED. But because of the particular circumstances in this case, he could still do that. Now, that he shouldn't have done this, there's no doubt about that. But Mr. Parker realizes that he came close to just ruining his life forever. Mr. Parker has a lot of family members that are here today. He has his mother, his father, his stepfather, his grandparents are here. He has uncles, aunts, cousins, and a number of family members that are in the audience to show the court that he has family support in this case. This is not a case in which he was going to be left by himself if the court decides to grant him deferred adjudication probation. He also has learned from his incarceration time. He's been in jail for about 4 to 5 months, and has learned that you can't stay in jail and accomplish very much. If the court grants him this deferred adjudication, he plans to return to his mother's residence upon release. He also is one of the few people that, if he were granted deferred adjudication, that he has a job waiting for him. This is through his father, through his employment at the refineries. This is an opportunity, Judge, where I think the court saved Mr. Parker just before things got really bad. And I'm not justifying anything that he has done, because none of this is justified. However, considering that this occurred when it did, he was quickly arrested, and probably saved his life in more ways than one. He would ask the court, and we can go into more details that he wants to address the court, to give him the final opportunity to receive deferred adjudication probation, realizing it's a very serious case, but this will basically save his life. He also has one child that he is going to be supporting, living with, as well as the mother, and the amount of family support that this young man has, I think, speaks very highly of his family, but is going to give him a chance to succeed in this case. And so, again, without going any further right now, I would ask the court to consider giving him one last chance for deferred adjudication probation.
How many chances has he had?
Judge, we can count. I believe he has three convictions, and one of them actually was dismissed, I believe, and there were probations. Now he has some other arrests. I'm not saying he does not, but looking at the number of times he has been in trouble as a juvenile, he has no TDC. He does have what I believe is 2 probations, and then as an adult, he is currently on 1 year community supervision for evading detention out of Harris County. And I believe that that is the only thing besides the pending cases.
Well, Judge, there's, hold on, are you through?
Yes, sir.
Okay, go ahead, say.
There's just one hitch in all this, and that is that in the pre-sentence report, there shows an aggravated assault with a deadly weapon offense on February 5th, which was indicted recently and got assigned to me after this offer was made. And so he's accused of shooting someone. So there is another offense in which he's involved in that we did not discuss in the plea bargain in this case because it got indicted after it came through the pike right as we were dealing with all this.
Yeah.
So he's got another second degree offense where a man was shot in the neck. So
yeah.
I would dispute that, Judge. I think we were aware of that, and I believe what the evidence shows, and I apologize to Mr. Laird. I don't mean to say anything about this, but I think we did talk about this. There were 4 people in a car that approached another individual.
Mm-hmm.
A person was driving the car.
You're talking about this other case?
Yes, sir.
But this has been indicted?
Yes, sir. It's been indicted.
Well, but it's not being dealt with today, right?
I don't show any of it.
There isn't anything else?
There wasn't anything, as I know, the
Is that
plea
what
bargain
you wanna do?
agreement,
Is
I don't have anything written down that
You
says we
wanna
were
dispose-
disposed.
I thought we were disposing of that case.
No,
today.
this is the aggravated robbery.
Yes, sir. I mean, you can double check the paperwork. I don't think there was anything dismissing it if we look at the plea papers. Huh? So there was one done? Okay, then I apologize, Judge. We'll
And
just.
again, that's the way I
Okay,
recall.
all right.
I apologize.
We're just dealing with this matter.
Yeah,
Okay.
I just didn't have it's still an open case in my files. Okay,
He didn't sign
okay. So,
I'm gonna sign it in a minute.
Okay.
If this disposal. Go
But-
ahead.
but otherwise, if he's done with his, I'll give my spiel on what I want on this case.
Go ahead.
Yes, sir.
Go ahead.
Judge, I'm looking at the story of the defendant. Kind of seems a silly excuse for showing a gun to a clerk, that he thought this was a joke. Looking at his prior history, with his chances looks like as a juvenile, he's had several chances of getting probation and getting himself straight. And then he's got the misdemeanors that he had. We would ask for the 8 years. So this is just ridiculous. Sticking a gun to anybody, especially store clerks, we have to protect them from people like this defendant, from placing them in danger, because guns can go off. Guns are intended for one thing and one thing only, and that is to kill. And so we would ask the court to give him the 8 years.
What would you like? Would you like to say anything, sir? If you want, this is your time. It's your life.
Well, yes, sir. I would like to say that I know I made a mistake, and I know that day that I wasn't thinking, but my intentions wasn't to hurt nobody or to scare anybody or to walk out the store with aggravated robbery. I know what I did was wrong, and it ain't nothing to justify what I did, and it ain't nothing to justify for me showing him a firearm and playing around with somebody like that. And I know that it was wrong, but I just want to learn from my mistakes and do right on probation, so I can beat up for my daughter, and beat up for my family, and go to work and go home and provide my son for my family. So,
What have you learned about hanging around with people that are in trouble?
if I hang around people that get in trouble, I realize they get me in trouble. So that's why within 5 months of me being incarcerated, I realized that I can't hang around nobody unless it's my daughter or my family that's in the courtroom right now.
Okay. Yeah. And you realize that if the judge is very lenient and decides to put you on deferred adjudication probation, but you could still end up doing life in prison.
Yes,
You understand that?
Yes, sir.
If you screw up one time, depending on the facts, the judge has that discretion to do that.
Yeah, so that takes a big part in and why I want to change for the better, because I know the circumstances of this case, and I know if you give me a chance, I know if there's anything that you could have did, and I ask that if you give me probation, I can show you show probation that I could be better for the community. I see me up court again.
How many times have you been placed on probation?
One time when I was 16, and one time when I was 12.
You're forgetting a few.
Then at age 17, I was placed on probation for misdemeanor out of Harris County. So, my other case.
Yeah, this juvenile, your juvenile history, you were placed on probation on March 23rd of 23 for 1 year delinquent court probation for unauthorized use of a motor vehicle. And then also on that date, you were placed on probation for evading arrest with a motor vehicle on March 23rd of 2023. Okay, that was a year before this crime was committed. Then while you were on probation for those juvenile cases, you pick up an evading arrest or detention in Harris County on November 28th of 2023. And then on July 1st, which was 3 months after you committed this crime, you're placed on deferred probation out of Harris County for that evading arrest and detention. Correct?
Yes, sir.
And then you've got this case you're dealing with. So in this pre-sentence report, God bless you. When you talk to the probation office on a pre-sentence report, you have to be forthright and truthful. And I don't understand why people aren't truthful. They have everything to lose because all of this is written down. You state to the probation officer here, you entered the store with two friends, playfully showing the cashier an object resembling a firearm. And you ask the cashier, do you know what this is? The cashier expressed discomfort. Now, these are your words. The defendant, then you put the object away while laughing. And then people stole something, a few items, and took off. That's it. That's what you told the probation office after you looked me right in the eye and told me you committed this aggravated robbery. There it is right here. I am guilty. Well, you signed it. There's your signature right there. Right there. Remember, under oath, swearing to tell the truth. I am mentally competent. My plea is freely and voluntarily made. I read the indictment, discussed it with my attorney. I am guilty of the offense and any lesser included offenses. I swear all of this is true, so help me God. And you pleaded guilty to committing, while in the course of committing theft, intentionally and knowingly threatening or placing the victim in fear of bodily injury or death. And you knew you did then and there use and exhibit a deadly weapon, namely a firearm. That's what you pleaded guilty to under oath to me. But you go back after that and talk to the probation office with nothing to lose by telling the truth. And you say you're hedging as to whether you really used a weapon or not. You said it's something that resembled a firearm. But you had pleaded guilty to me under oath for aggravated robbery. Even at the end, you're not telling the truth. Even at the end, you can't be forthright. How can I trust you on probation when you're not forthright with us? You say one thing under oath and then you go back and say something else to the probation officer. It's hard to believe you. You're a grown up. I hadn't been a grown up for long, but you're a grown up. You're an adult, correct? And you've got responsibilities. You've got a family, you've got a child. Yeah. And yet, with the family at home that you're supposed to be taking care of, you're out with some other thugs robbing, using deadly weapons. You know, the victim could have easily pulled out their own firearm and shot all of you. And they'd probably be given an award for doing the right thing and making the town better when they were threatened with their life. But when somebody takes a gun out and places a gun in front of somebody in their face, they think that's the last moment of their life. That's what they all tell me, that I'm no longer in power. I'm no longer in control of my life. Some stranger like you who doesn't have the right to do that is in control. And one stupid, foolish pull of the trigger is the only thing left between dying and living. That's not fair. That's not the way it's supposed to be. You knew better. You had important responsibilities at home. You've been through the system several times. You know, making mistakes has accountability. You're going to be held accountable in this. The fear people have and the waking up with the night sweats and nightmares the rest of their life, looking at a firearm and someone else is in control of their destiny. It's not right. It's not fair. Then the law provides punishment for that. And you knew better. You had so many more important things to lose. And yet you made the choice to hang around bad guys and play with guns and threaten people with their life when you should have been at home. And you've been through the system. We've given you chances. You have made mistakes, and you just have made an even worse mistake after being on probation for 2 or 3 cases. I'm giving my spiel. I hate to see a person's life wasted, but each of us makes the choices, and that's what we have to live with, the choices we make. And you have family and probation people who have helped you know better, and you still did an even worse act than before by threatening somebody's life. And Stephen, and that carries with it, a crime like this carries with it up to life imprisonment. My goodness, that's how we treat it. It's important. It has the same punishment range as murder because it has serious consequences. Oh, here's what I'm going to do. I'm going to find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt in this offense of aggravated robbery with the use of a deadly weapon, namely a firearm. I am following this agreement. You were hereby sentenced. You were hereby found guilty beyond a reasonable doubt and sentenced, as I follow this agreement, to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. You will be given credit for term for time you have served, and the judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Do you understand what has happened today, sir? You have been held accountable for making a terrible mistake that you knew better. Now, we have one other case, correct? There is a motion to dismiss that case. And it's 24 CR 1056.
Yes.
Stand by.
Yeah.
It's 25 CR 491. 1056 is what the court just sent us the defendant to. The other case pending is hereby dismissed as part of this agreement. Do you understand what has happened today, sir? Speak. Okay, good luck to you.
Is there some further business?
Okay, I didn't want to interrupt that whole hearing, but Barbara, thank you so much for the $5 on behalf of Ellie. I will make sure she gets some kind of lovely treato for that. As always, I appreciate you. Appreciate all of you. You know, as I said last week, this is the best place in LawTube, and I'll go to my grave saying that. You guys are wonderful, and I truly mean that. Let's go back to Judge Stevens because he just had somebody else walk up. But after that, you have a choice. We can go to Judge Boyd or we can try something new. Put a 1 in the chat for Boyd, a 2 for try something new.
A formal reading of this indictment and arraignment can proceed in summary. Yes, sir. In summary, this indictment alleges that on or about April 5th, 2022 in Jefferson County, Texas, you committed the 3rd-degree felony of escape. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement?
Yes, sir.
And of course, there was that prior conviction that would have enhanced this up to 20 years in prison. If I follow this agreement of imprisonment of 10 years, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1, in evidence without objection admitted. The state you are mentally competent to enter your guilty plea. It's freedom and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer.
Yes, sir.
All true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is one. I'm going to follow this agreement, sir. Nothing further. You were pleading guilty. I find voluntarily, knowingly, intelligently, you are mentally competent to do so. There's sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this 3rd-degree felony of escape. I now find you guilty of this 3rd-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice, serve a term of 10 years, as I find you guilty beyond a reasonable doubt based upon the evidence in this plea agreement and the plea papers here. Do you understand what has happened today? Yes. Good luck to you, sir. Thank you. That is all.
The crowd has voted try something new. We're going to go to Adams County, Colorado. This is their bond court. Their feed is a constant stream. We cannot rewind or anything, so we catch it where we catch it. Let's see what's going on.
Learned that when he was asked to leave the hotel room, he did not, and the police ended up having to break the door down and cause significant damage to the structure. I'm glad that Mr. Mohan was not hurt in all of this. I don't think that a personal recognizance bond is appropriate. I will set bond in the amount of $1,000 cash or surety with a $100 cash option.
Speak now. Don't say anything. I would advise you not to say anything.
Mr. Garland. Okay, Mr. Garland, this is Roger Mohan speaking. I did have a hotel.
You should listen to your counsel, sir. Your next court date will be June 30th in the First Appearance Center for an arraignment at 1:30. June 30th.
Mr. Garland.
First Appearance Center, 1:30.
The judge.
Okay, Mr. Garland, I'm sorry. Let me please speak. I do understand that you're advising that I don't speak, and I do want to make it. And I also understand the advisement of my public defender at this personal time. Despite you not being able to send a personal recognizance bond in this particular matter, and I know the concerns that were raised, I was under the impression that my hotel room was paid for, and
Your Honor.
despite I no longer
going to change it, and this is going to be used against you, and it's going to be I just don't.
If I
think-
do not get out on a personal recognizance bond today, I will lose my dog and I cannot allow that. I know that there are concerns and I know that competency can you, okay, I won't. I know that there were some issues that you brought up, including competency and diversion. I swear I would not miss this court appearance by any means. I know that there's a very high score that's been raised, bring me to a category 4. Despite all the things that you might have before you and the fact that I'm not a habitual offender of the court system, if I lost my dog today or was not able to get out on a PR bond, and I know that's something that you said that you would be opposed to as well, I have nothing else to live for. Intrinsically, why somebody wakes up in the morning and continues on with their day, that intrinsic reason for me is my dog. And I would have never, and even in the regarding this case or not regarding this case, put myself or my dog in harm's way. And if I would have known that, I would have easily left the hotel rooms. Please reconsider me getting a PR bond despite the advisement of any other person. If I do not, I don't think there's anybody else that could take better care of her than I. Please.
I'm not going to reconsider it. Have a good day, sir. All right, let's call the two Mooney matters. This is 25M3160 and 25M1889. Mr. Mooney was a refusal this morning. Both matters, the bond will be set at $1,000 cash or surety. I will appoint the public defenders to represent Mr. Mooney while he is in custody. Both matters will be set June 30th in the first appearance center for an arraignment at 1:30.
Your Honor, could you say the case numbers again and the bond amount for both? I apologize.
For Mooney, the new case is 25M3160. The other case is 25M1889.
Thank you. And bond, Your Honor.
$1,000 cash or surety on each.
Perfect. Thank you.
All right, can we call People versus Moises Perez? Good morning, Mr. Perez. This is 25M3162. That is 25M3162. In this matter, I did review the affidavit for probable cause. I did find probable cause for your arrest. So I will appoint the public defenders to represent you while you are in custody. We need to address a mandatory protection order. We need to address your bond, and we need to get you a new court date. In this matter, I am going to issue a mandatory protection order. This is not governed by Brady. The protected party will be Perry Benson with the date of birth that's listed on the pretrial services report. I'm going to check boxes 1, 2, 3, 7, and 8B. What this means, Mr. Perez, is that you may not have any contact whatsoever with Perry Benson. You must stay away from his home and his work and any other place that he is likely to be found. You shall not harass, molest, intimidate, retaliate, or tamper with any witness to or the victims of the acts you are charged with committing. Additionally, you may not possess or consume any alcoholic beverages or controlled substances while this protection order is in effect. And the conditions of this protection order are conditions of your bond, which we can address now if the parties are ready.
Your Honor, I'm really sorry. Can you say the case number one more time? I apologize.
No problem. 25M3162.
Thank you, Your Honor. And we are ready for bond argument.
Go ahead.
Your Honor, Mr. Perez would be asking this court for a PR bond. If that's not deemed proper, he would be asking for a reduction in the alternative to half of what it's currently set at. Mr. Perez has lived in Colorado for the past 10 years. He's currently unemployed. He actually has been unemployed since he was 17 years old. He is working on getting on food stamps, Medicaid, and disability. He would be looking to stay at a homeless shelter in Aurora. If he is released on this case, there is one he has stayed at before that he intends to go to and try to find a bed. He also knows how to use the public transportation system to get back to court. He's intent on making all of his future court dates. This includes using the bus or the light rail, excuse me. As far as the CPAT risk category, although it is a 3, it is relatively on the lower end of the scale at a 41. I would just note that 15 points of that were for age of first arrest being under 19 years or younger. Based on these mitigating circumstances, we would be asking the court for a PR bond in this case. Again, if that's not deemed proper by this court, we would be asking for a reduction of bond, something along the lines of 500 cash or surety or $100 cash option. Thank you.
Thank you. For the people.
Your Honor, the people would be objecting to a PR bond at this time. I think the bond is at an appropriate amount based on the CPAC category risk of 3. And I'm looking at the criminal history, and there are several FTAs and OFJs.
All right, thank you. I've heard the arguments of counsel. I've also reviewed the pretrial services report, noting the risk category 3, the total score of 41, the criminal history listed on the back of the pretrial services report. But most concerning to the court is what's in the affidavit, that this has been an ongoing issue between Mr. Perez and Mr. Benson and the place where he works. I don't think a personal recognizance bond is appropriate. I'm going to set bond in the amount of $1,000 cash or surety. I will authorize a $100 cash option. The next court date will be June 25th in Division R for an arraignment at 1:30. All right, can we call People versus Joseph Trujillo? This is 24 T6409.
Joseph Trujillo.
We don't have him in the courtroom right now.
I'm sorry?
We don't have him in the courtroom right now.
Okay. Did we get,
I'm
counsel,
sorry.
did you get it?
I think he was on with Denver, but we can get him on here momentarily.
All right. Did we have a chance to talk to Darren Martinez?
No, Your Honor, but I'm going to do that next.
All right. Let me know when you guys are, that's all I have left. So let me know when you guys are ready to call some.
There we go. And the timing is perfect because, quite honestly, it's time to be done for the day. I hope you all had fun. I know I did. Got to look at something new. Got to listen to Judge Boyd rant at somebody. Yeah, not that bad of a day. Oh, by the way, I can confirm that Judge Glazer finally did take a lunch break. So I'm sure the people who have to see her later today will be very thankful for that. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. We will again add a third hour. We're going to do that all week. We won't have as much as far as long form and shorts on the channel this week. I'll do them when I can. But as many of you know, my daughter is in town for the week, so I'm trying to spend some time with her as well because I don't get to see her every day. So it's a good thing. Often you guys ask me what you can do to help. And first off, that's very much appreciated, more than you know and more than I can express. But I have an answer for you, especially this week as I will have less content. One of the best things that you can do for me is share the show with others, share the channel with others. So if you have social media, if you're on FaceSpace or Twix or GeoCities, or you're still on AOL, I don't care where you are. If you can share the show with people so they can discover it, those things are incredibly helpful, and that would be how you could help me this week. So I'd appreciate that a lot. But I'm gonna shut up now and let you guys enjoy your day. I'm gonna go enjoy mine, and we'll see you tomorrow. In the meantime, have yourselves a great Monday, and take care, and God bless.